I think they can hear me online, so I'm going to get rolling. I'm Mark Gardner. It's very nice to see everyone here. Got a great turnout. We had 308 people sign up for the program, so I was very, very proud of that. Obviously, most people are online across the country. So thank you very much for being here. We're celebrating 10 years as a Gardner Law, so very excited about that. Time flies, as the old saying goes. We're going to talk about the past, present, and future of FDA law, regulation, healthcare compliance, all the business transactions that we all do. We're going to talk about litigation. I'm excited to introduce the panel here. It'll start us off on that. I just wanted to step back a little bit, memory lane. Like, I've been practicing law now 17 years, I think it is, if I add it up. 10 years before that I was in product management and was in biotech, medtech. I went to work for Mark Duvall. He gave me my start. Worked for him for 7 years and started Gardner Law 10 years ago. So I think my math is right on that. But it's been kind of, it's been amazing. I just want to take a moment to thank our clients. Without our clients, we'd be nothing. And also the amazing team that we have, and they will introduce themselves today. Yeah, we have all 12 of our lawyers here today. So you're going to hear from 12 lawyers. We also have 4 panelists who are lawyers. So what better way to spend an afternoon than with 16 lawyers talking to you about all the things that are going to happen. But hopefully you'll learn some things today. That's, you know, the intent is to take away some things that will help you in your practice. We have a range of lawyers, regulatory professionals, quality professionals. We have some folks from the government here today, private sector, so very exciting. I think everyone knows what we do at Gardner Law. We represent makers of medical products, foods, and cosmetics, and we have practices spanning regulatory. We're engaged in Nate talks with FDA constantly, and our team, we have healthcare compliance practice, privacy practice, business, commercial transactions, and we're growing our litigation practice as well. Talk more about that in just a minute. So we have 5 sessions. At the end, we will have a little happy hour back here, and Tracy is looking around. Do you need something? Okay, we're advancing the slides. All right. We're going to talk about, you know, the past, but what's really exciting is what's coming next. And I know that we're all working in this industry, drug device, biologics, digital health. There's so much cool stuff coming out. It's kind of mind-blowing what we're on the precipice of. So we'll talk about AI today, personalized medicine, how technology is just exploding, and I'll stop talking now and hand it over to Amanda. We have Amanda, Vivian, and David. Vivian is our newest attorney. David is our litigation team. He and Vivian are and what? Former litigators that work on various, you know, FDA regulatory matters, healthcare compliance, et cetera. And Amanda is my partner and leads our compliance practice. So Amanda, I will turn it over to you.
Yes, and thank you. Just before we get started, some housekeeping. So this program has been approved for CLE credits, 3 through the Minnesota Board of Continuing Legal Education. If you want to request a CLE certificate to self-report in other states, there's an office at Gardner.law. This program was also approved for RAPS course credit for 3. Restrooms also are right back there behind the bar, and we encourage a dialogue. So if you guys have questions, please raise your hand if you're in the room. If you're online, there's a questions feature within the GoToWebinar, and we'll be keeping an eye on that. So please ask questions. All right. Well, thank you. We are, well, actually, let me switch my slides. I am pleased to be moderating a panel on litigation and government strategy. And I am pleased to announce my panelists, or my joint presenters here. Our newest employee, Vivian, just started on Tuesday, so this is a big first week for her, and David. And I'll let them introduce themselves a little bit. But we're going to talk about litigation, kind of what's changed in the last 10 years, what we're seeing today, and also just kind of things to keep in mind for companies going forward. All right, and I'll just briefly, my name is Amanda Johnston. I'm a partner at Gardner Law. I've been with the firm, I think I was actually the second lawyer after Mark, so I've been here about 7 years. So I've seen a lot of growth. It's really exciting to see such a big, amazing team that we have now. So I will pass it on to Vivian and let her introduce herself.
Hello, everyone. My name is Vivian Edbu, and I'm an attorney here at Gardner Law. And so I've been practicing for about 14 and a half years. I started my career off in civil litigation, so did that for about 10 years. And then I moved into government work. I started at Health and Human Services Commission in Texas in the Healthcare Enforcement Division. And then after working there for a couple of years, I then moved to work as the Assistant Attorney General for Texas. And that was my position prior to joining Gardner. And in that position, I prosecuted, oh, can you guys hear me?
Turn it on.
It is on. Okay, sorry about that. So can you guys hear me okay? Or should we wait? Okay. So as an assistant attorney general, I prosecuted healthcare fraud cases, and most of those cases were illegal kickbacks and false claim, false promotion. And I also got certified in healthcare compliance. So that's a little bit about me. Great.
And now that you're with us, it'll be alleged false claims.
Yes, exactly. Alleged illegal kickback.
Right. I'm David Graham. I started my career litigating, did for 25 years or more, for medical device and drug companies, product liability cases. And in the late 90s, I started doing cases for drug companies, but they happened to be related to animal feed and food related things. And so I got interested in doing food law. And I've done that along with other medical device and drug cases. So I work on those kind of cases, but also increasingly working in opposition with, hopefully sometimes with, state agencies and the FDA and USDA in disputes about whatever our clients are challenged with.
Great, thank you. And we're going to start out, David's going to do, oh, sorry, I didn't go over the agenda yet. We're going to talk about how the government shows up, things that you should be thinking about, how that's changed, what drives escalation in investigations and litigation, how cases actually unfold, and then we'll do a little bit of a panel discussion. So I will hand it over to David to do a brief primer on enforcement.
I was going to stand up, but I think I'll stay here because I just block everybody then. So I hate to be rudimentary for those who've been in this business a long time, but I often have clients that don't understand that FDA enforcement or USD enforcement is law enforcement. So it's not just because you interact with them often doesn't mean that they're not just like an officer of the law that tells you not to speed or to do something different. If they tell you to do something different, you better have a good reason not to do that, right? And that understanding sometimes can help avoid problems. The law enforcement incentives don't change, right? It's protecting consumers and patients particularly from physical harm, consumers from fraud or misleading advertising or things like that. That doesn't change no matter who's running the regulatory bodies in question, and fraud. So protecting the government purse, whether it be the state or the federal government, is always fashionable. Again, it doesn't matter which party's involved. So that's the perspective of the agency, and that's their job. And keeping those things in mind sometimes is helpful to not being faced with an escalation in enforcement. So, and now what we're seeing that I don't think I've seen as much of in 30 some years is more state involvement in food additives and having laws specifically related to that, and laws specifically related to the regulation of advertising around medicine and medical devices, where that was completely the province, or the states were happy to leave it to the federal government to do. And that context. So that's kind of my preface. So state and feds work together a lot. Sometimes it's good. In Minnesota, usually it's good for me. We have a great Department of Agriculture and Health Department here, and when they're involved, they're responsive usually, and it's a good thing. I don't know about every other state in the union, but some aren't as good as ours, I don't think. Some of the tools that they use are one we left off there, and that's my fault, is recall. So in all matters we deal with, you're always trying to prevent market withdrawal or recalls or things like that. So that's always a tool that's a civil remedy that they don't need permission to engage or force in terms of going to court. Otherwise, it's inspections and interviews with people, market surveillance if there's a particular kind of product that's causing a problem, a particular kind of promotion that's causing a problem. We're going to learn more about what the government is looking for in a minute from Vivian. But those are the general tools. So they don't change much over time. I mean, they can detain products. They can prevent shipment to the extent it's in interstate commerce. So they can interrupt your business to the, I do, this room, probably not the audience, but the USDA, for example, if they don't show up, you're out of business. You have to have a stamp, right? So it's from that extreme to finding out in an inspection that your label's wrong, or in a different context that might stop you from shipping product or things like that. So those are the general tools. Am I leaving any out that you can think of?
No, I think you covered most of them.
Okay.
Yeah, criminal, civil, consent decrees, fines.
Right.
Yeah,
Right.
and we'll talk a little bit more about kind of
Right.
how we see that.
Right. And so the next part is what makes things worse, right? You have a problem with FDA and maybe it rises out of an inspection and an FDA 483 and you can't resolve the issues in the closing meeting and you don't do the right things to resolve it. Let's put it that way. Nate doesn't help you. No, so there's always a problem with not doing what they ask you to do or not negotiating properly with them what you have to do. So just blowing off the FDA is always a recipe for escalation. If there's risk, obviously physical risk to patients is number one. If it's a medical, well, and food too, right? I mean, if there's a food outbreak or there's evidence from adverse event reports that people are being harmed, that'll drive escalation fast. Now the escalation might just be a recall and that takes care of it. So in any event, that's failure to act in good faith is the worst because it's not only maybe illegal if you lie to the government, that's a crime in itself, but if showing disrespect for the people who are trying to resolve the problem with you will always make it worse. Unfortunately, I show up after that disrespect has been shown already, unfortunately, and you have to repair that because what do you lose then? You lose trust. And without trust, it's hard to get back going, even if you resolve everything. So in any way, and then fraud, of course, if there's an indication that there's ill-gotten gains, it's a problem. So what triggers them? Well, it could be recalls, it could be FDA investigations of another company or a particular product. It could be an inspection where something's discovered, a complaint from consumers, a complaint from competitors, and whistleblowers, of course, are always people that can get investigations going. And whistleblowers come about because you didn't pay attention to them when they complained in the first place. Or even worse, you treated them poorly or fired them. What are the tools? We talked about some of them, but investigation tools include asking for documents, asking for interviews. One we don't have up there is search warrants. So if they can get a judge to sign a warrant, they can use that to find out about very specific things that they're investigating. And then the paths to resolution are, hopefully you just respond to the inspectors or investigators as it goes on, and you can work it out with them. And maybe even avoid an agreement or a consent decree. You can just resolve the matters. Usually it ends up in some kind of letter agreement with the state or consent decree with the federal government. And hopefully you don't go to trial on some kind of civil matter, like a False Claims Act case or something like that. And then the other way is criminal prosecution. And you don't ever want to get there because that, it happens. And again, that's usually because you ignored evidence that something bad was happening in your company. Not only ignored it, covered it up. So that's sort of the introduction.
That was great. Just to kind of level set what we're talking about here. And now I get to ask questions of you guys. So first, Vivian, welcome to Gardner Law. We're very happy to have you. You've been litigating in the government for the last 10 years. How have government investigations changed over the last 10 years from your perspective?
Okay, I can say, and I haven't been in government for 10 years,
Yes,
but for about 5 years. I would say within recent years, the government has become a little bit more aggressive in intervening in cases. And when I say that, I mean, anytime there's an action against a healthcare company, the government does monitor, but they also have an option to actually intervene and be a party of the case. And so that has increased exponentially lately. Can you guys hear me? Yeah. And what that means, that has a very important meaning to the companies, because once a government intervenes in a case, there no longer is a statute of limitation. So whatever the allegations, whatever the amount that could be, the government can go as far back as they can prove, rather than just, the 5 years or 10 years that would have held the limit on the claim. So that could be a significant impact on a company if they are successful on the claim. So that's one really big thing. Another big thing that has changed through the years are what type of cases the government will pursue, because the government hears about a lot of cases, but they don't always have the manpower to actually pursue the cases. And it used to be based purely on how much the damages were or how much the alleged fraud was. But in recent time, governments are also looking at patient harm. So even if the amount is small, if many patients were harmed or it's a concern of public safety, they will pursue the case. So those are a couple of big changes I've noticed through the years.
David, do you have anything to add on that?
Yeah, I would add two things. One is I think there's more state and federal cooperation and enforcement that's driven by resources. If the federal government doesn't have a lot of people to investigate, much less, well, first of all, inspect, but then investigate if there is some specific issue involved, then they can use their state partners, and they seem to want to be more willing to do that and not just keep it in their own arena. And then I think a little more willingness to force recalls and use administrative detention and exercise their muscle to stop commerce. I'm not saying they're wrong every time, it just seems like we weren't always there so fast. I had a matter that it actually had been going on a while, but the actual quote evidence that the FDA inspectors had, which they thought would justify a recall, they gathered 3 days before they said, we need a press release for a recall, right? Usually you got a little time to work it out. What was the problem? What was the result of the testing you did? How can we address this? And it was not, it was pretty quick trigger. So I think a little faster on things like that. Yeah.
Can I just add something that David said is true about resources? The government does have limited funds, but another thing that has expanded their resources is whenever there's a whistleblower, which a lot of these cases start from whistleblowers, they are usually represented by a law firm. And so when they intervene, they also have the resources of that firm, which is usually pretty large. So that also expands what they can do and how far they can go with a case.
Yeah, that's a really good point. And I think there's a question online.
Yeah, there is. What is the consequence of not responding? I'll start over. Are we good, Charlie? Here we go. What is the consequence of not responding or acting on warning letters from FDA? Is there any data on fines or civil or criminal actions FDA took if companies didn't act on warning letters? And does FDA have power to ask for recall or discontinue product for non-compliance if there is no safety hazard to public?
So the risk of not responding to a warning letter. I mean, I wouldn't advise that.
It's high.
I mean, they do have
complete power to
yes,
shut down
they do have
that product anyway.
authority
Maybe
to
not
stop.
your whole business,
Yeah.
but yeah.
Yeah.
And I can also say that that would increase the scrutiny on the company
Yeah.
because now the government is even more interested in what's going on.
Yeah, if you don't even respond. Yeah. I mean, obviously we don't know the facts, but I think just common sense, anytime FDA is coming to you with something, especially a concern, it'd be very wise to respond. They're not going to go away. They're going to keep coming back and it'll escalate.
It will escalate.
Yep.
I think most of their enforcement tools are at their disposal in that kind of
Yeah,
thing.
yeah.
I've always assumed that. I mean, you can challenge, right, based on the evidence and maybe they were wrong in their warning letter, but
Right.
why would you wait?
Right. Yeah.
It's a fight that has to be had either way.
A warning letter is simply a warning. So if you ignore it,
Right.
then the government will
Yeah.
just pursue you.
Right. They're not going to go away.
But
Okay.
you can operate with open issues from
Right.
warning letters as long as you're working on them. I mean, I've never.
Right. Well, especially if it's not safety, you should be able to have conversations with FDA and try to explain why maybe you disagree with what was in the warning letter or the deficiencies. But yeah, I wouldn't recommend ignoring. Okay, so another question here, David, I'll have you start this one. When a company first learns of a government inquiry or investigation, what usually happens next, or first, I guess, and what are the biggest early mistakes that companies make?
I think the biggest mistake is not having a plan for this to happen. So if you're in a more mature company, you usually have at least the team that's involved in dealing with inspectors, right? So they'll be kind of familiar with working with the FDA and so be prepared in advance, right? Not training people is another mistake about how to deal with somebody who stops you on the street and asks you questions about the business you work in and telling them their rights. I mean, it's not a long conversation as you can tell them, right? Or you can say, no, you know what, I can have this conversation with you, but I want to do it with the presence of my manager at my company. Or, I mean, you can exercise that, right? So if people don't know that, they engage in the conversations and aren't, that's a very uncomfortable. I don't know if it's comfortable if you're a lawyer, but it's, so I would say that. And then communications within the company aren't controlled, not that you're suppressing information, but you're not allowing speculation to drive what your response is. So you're not constantly reacting to what employees might be saying and you're trying to get them educated. And also the C-suite, make sure they understand what's going on. There's not always perfect judgment there. And so that's how I'd initially answer the question.
Vivian, anything from your side, kind of seeing companies being under investigation, anything that would cause you to apply more scrutiny?
I would say more scrutiny comes from what we gather from the interviews and the documents. If there are any hesitation to produce documents, that will raise an eyebrow, or if we're ignored or there's no cooperation, that definitely will increase the scrutiny. So just going along through what we learn normally determines what we feel about a case.
Can I say one other thing? And that is when it's at the level that there's interviews or document requests, it's not, gee, I'll just reach out to the people I know at the FDA that do the inspections and see what's going on. they may have no idea, and it's just best to have some experienced counsel if you don't have it right in the firm, and then proceed as if it is an investigation, not just a routine inspection.
Yep. Okay. And we've been hearing a lot lately about cross-agency collaboration. The DOJ, CMS, FDA, we've seen a lot of different initiatives coming out talking about how they're working together and collaborating. What does that actually look like in practice? Vivian, you can start.
Yeah, sure. So in practice, we essentially, the agencies will have regular meetings together, and the purpose of those meetings is just to see what's on the radar, what's going on in healthcare and companies, and one agency may have access to information another agency needs. And so we do get together and work together and, see whether or not there's enough merit to pursue the case, or if on the federal side, they want to settle or they want to dismiss the case. Sometimes that will affect the state unless the state has more strict laws, and so they could pursue it. And sometimes on the federal side, they're not willing to share all information with the state. So it can be difficult state to state as well, depending on, which state is involved. But we do get together and collaborate, and it's just bringing resources together for the common goal.
From my perspective, it's the back end of the litigation or consent decree to make sure that you have OIGs satisfied. You're probably working with the DOJ, well, but then the OIG and then CMS, whoever might want money. Right?
Yeah.
And then the state, you got to make sure everybody knows that there's a settlement that should know. Hiding it won't work because it'll eventually. So sometimes there has to be separate, or if everybody's not included in the resolution of the matter, they need to soon to be made aware of it, and you need to reach out to them before you tell you're satisfied that you're not going to have any more accountability elsewhere, and see, if that makes any sense,
yeah.
especially in False Claims Act cases.
Yep. Okay. Looking ahead, what enforcement trends do you think companies should be focused on? Vivian, you can start.
Vivian, oh, yes, okay. I would just say, looking ahead, the enforcement trends are really the states getting more involved in the action. That's really going to impact the company as far as the damages and racking up the alleged amount that was illegally collected. And so I think to stay on top of that, it just boils down to your compliance program, not ignoring customer complaints, taking those seriously, because in discovery, the emails, the reports of products not working, all of that information will be released. And the way the company reacted to that is what's going to determine some of the damages. So staying on top of compliance, taking complaints seriously, addressing employees that aren't happy, that's major, because that's where these cases stem from.
Absolutely. A lot of whistleblower cases. And we'll talk about that in the compliance session as well. But David?
I would just reiterate faster use of enhanced enforcement is. So I did a recall, and over the holidays, we sent out the press release and the letter. And the next day I got a notice that it wasn't a successful recall. It seemed pretty fast, right? Especially with the clientele we were dealing with and who was receiving the letters and the time of year. And I was just like, well, that seems, because they went out the next day to interview store owners to see if they received the communication.
Oh, okay.
Finally, we went door to door. Sorry to do a war story, but, and of course they never would want that before, because then they assume you were diluting the original communication, right?
Sure.
So I think there's just a quicker trigger now that you should be aware of.
Okay, that's helpful. We have any questions in the audience? in person or, yeah. Oh, wait, we'll grab a mic for you.
So this is a question about discoverable information with respect to meetings. So let's say your company gets a notice from the FDA, it may be about a recall or something, and everybody gathers together on a video, and somebody's real smart and wants to use one of these transcribing software programs. And the next thing you know, you have a verbatim minutes of your meeting, and somebody during the meeting said something they might not want to have publicized. So the discoverability of these meetings are video meetings where there's automated transcriptions. I'd like to have you comment about that.
I can certainly comment about that. I had a case at the AG's office where one of our smoking gun pieces of evidence was of one of the sales team recording a meeting. And in the meeting, the company was training the sales team on how to twist the words and essentially exaggerate what the product could do, and said, make sure you do not leave any of these handouts at the hospitals or clinic. We don't want any evidence. And all of this was recorded, and it was subsequently produced in discovery. And it was something that I used in a deposition, and it's not privileged unless it's privileged information, meaning it's protected because someone is talking to their attorney or husband and wife. It didn't meet any of the exceptions. So it was 100% admissible, and it was very damaging for the company. So you really do, I mean, you don't know if even right now someone's recording, right, but you do want to be careful. Maybe make a note before a meeting and say, hey, please no recording. And, you know, just take the proper precautions. First of all, don't do anything illegal. But also, you know, you just want to make sure that it's an environment where people are comfortable asking questions, and so you can help your company be successful.
Those note-taking AI things are all over the place. I don't advise using them, especially with the lawyer on the phone. I mean, yeah, you'd ultimately have to be forced with trying to argue that they're privileged. And if there's not a lawyer or if there's not a privilege that would apply, it would be discoverable. So I just not a huge fan of those note taker capabilities that pop up in the meetings.
Yeah, and then running the recording through, AI is maybe a little better.
Yeah.
But it's still
Right.
a quote third party.
Yeah.
Hey everybody. Is this on? Yeah. Okay. My name is Daria Lucas. I'm with the group's regulatory. I'm with the firm's regulatory group. And I see this all the time in larger organizations or organizations that have multiple functions. And I've sort of just made it a regular practice to, because a lot of these functions, they don't know that, you know, this is discoverable information. And so I make it a regular habit to, you know, tell them, please turn off that transcription. I'm regulatory counsel. This is, you know, a privileged conversation. If we want to keep it privileged, that should be turned off. So.
Yeah.
Very.
Oh, we have a question over there. Mike?
Hi there. In regards to Escalation, I have firsthand a company that was requested by FDA read-only access to their EQMS. Ultimately, the company granted it. I was at the FDA a long time ago. That was not something that we were requesting access to. And I'm just wondering on the legal basis of that and where's the refusal line drawn?
So they requested a full access to the software platform with, okay. I mean, I haven't had that come up. I don't know if anybody else has, where you'd actually hand over access to a portal or a software. I mean, handing over policies upon request is one thing, like paper. Yeah, I don't know. Does anyone have thoughts on that?
Yeah, I think you have a right to refuse that request or negotiate parameters.
Yeah, like a scope of what they're looking for.
Right. What do you want to find out? Maybe we could just provide it to you in a subset. Yeah. So.
Yeah, usually it's just paper document requests.
Go ahead, Ann.
Yeah, Ann might have.
And one thing you could point out is if it's a validated Is this on? If it's a validated system, providing them access isn't what you do with a validated software system. So that's one thing you could try, is that actually it wouldn't be appropriate for me to give you access. Yeah, so they're doing this more. I think negotiating is your best first step. And then you may have to. The other thing is privacy. If they're looking at anything that has patient data in it, that's a different set of requirements that then you have to get over that hurdle. So there might be things that you can just point out as issues, but.
We have 3 minutes. Any other questions? Any online? No? Mark? We have 3 minutes left. I think that's for the.
Gonna make a quick point that with these AI trackers online, I'm like Daria, I hate those things. Calls, and a lot of times they're just automated, so they keep coming on. But I would be careful also if you are using AI to get legal advice. It's not an attorney. Your conversation isn't privileged. If you're putting it in Gemini or some other, whatever, there's a lot of them now, Claude, et cetera, OpenAI, ChatGPT. There's a court case on this. You can look it up, but there's a lot of issues with attorney-client privilege and confidentiality with those using chat and whatnot for legal advice. So I know Jake and I were just dealing with this the other day. There was this person emailing us helping our client, and I'm like, I think that's a robot talking to us. And Jake's like, yeah, it turns out it is. So we have to go back to our client and be like, this thing that you are calling Susie general counsel is a robot. That's not, you don't have ACP with that thing. So, but yeah, I just wanted to add that.
Yeah, and it's discoverable, your whole conversation with ChatGPT, so, or any of the things. So just something to keep in mind.
Isn't the AI program capturing also it's not just giving you a summary of your conversation, but it's actually putting it into using it to build its own prior.
Yeah.
So it's just a sophisticated listening post. Yeah.
All right.
One more question, I think.
Yeah, one more question. Okay, I was going to say, yeah, we have time. Got a minute.
I just had a question in the same vein regarding, so what I've been coming across lately is with regards to smart communications and sort of write it right. So you want to be able to instruct the sales team, the business generally, that they should think about what they're putting in writing. They should think about how they talk about things. But you don't want to insinuate that it's okay for them to have the underlying intention, but they just have to, phrase it differently. So we've been thinking about how we communicate that in terms of, do they, you want to think it right and write it right? But I'm just wondering what your perspective is on how far you can go with regards to advising the business on smart communications, how they talk about things, how they write about things.
The write it right piece is always a part of my compliance training. I mean, really, you have to get them to understand the rules and why it matters before they can understand how to write and how not to write. So I think it comes down to just training and sharing kind of the reason why in a way that makes sense to whatever audience whether it's sales reps or clinical or R&D or executive level, getting to understand and appreciate how it impacts them and the company and our customers. That's kind of the prerequisite to the write it right piece, but they both have to go hand in hand. I don't know if you guys have any thoughts.
Yeah. So I was privileged to be opposite Robbins for the first 20 years. Robbins captained the law firm when Mike Cerisi was there, and marketing documents is what he wanted first all the time. I mean, that's the key that unlocks liability, and not scientific liability, not the odds exactly of whether a device or a medicine will cause harm, not that, but about the company conduct. And it's because he was great at distilling a case into what do you know, when did you know it, and what did you do about it? And that the marketing documents. So if you can somehow, without just sounding like a complete, fear monger, communicate that it's a portal. Even doing it really well can be a portal to problems. Might help. I don't know.
Okay, good. I think we're at time. So thank you, Dave and Vivian. Thanks for everybody. The good questions.
Really awesome.
As we settle down, really thanks to the litigation and enforcement panel. That was a great panel, and it's really relevant, right? When you're talking about FDA, you're talking about compliance, all those things. Remember what you learned in that first panel. We're the regulatory team at Gardner Law. We're going to shortly introduce ourselves, but just wanted to give you a clue of what we're talking about is a changing FDA, leveraging what we've learned, how to apply it to the future. Right, when you think about FDA-regulated product getting on market, whether it's a medical device, a pharmaceutical, that takes years, right? And when you're talking about years, you don't have the privilege of adapting month to month, right? That can pretty much burn out all the capital you might have. And so really understanding what the playing field that you're trying to enter onto is and trying to be as creative as well as predictive as you can is important in this space. I'm Nathan Downing. I'm on the regulatory team with my colleagues here who will introduce themselves. I've been with Gardner for 5.5 years. Really enjoy the work, really get to see a lot of unique products, a lot of unique ideas, help clients bring those to market, but there's also post-market concerns, a lot of different things that come with our work that is really enjoyable. So we'll let each person introduce themselves.
Okay, well, these fine folks. I have been at Gardner Law for about in advertising and promotional and the advertising and promotional space. So we work with teams regularly on making sure pieces are compliant.
My name is Daria Lucas, and I'm also in the firm's regulatory group, as I said. I assist with submissions. I assist with ad promo reviews. I also dabble in compliance and help our compliance group a bit. So I've been with Gardner for almost 2 years. I'll have my anniversary next month. So.
And I am Bryn Stanley. I've been with Gardner Law for about 6 years. Prior to that, I worked in various quality roles at several medical device companies around the Twin Cities. I am an engineer by trade and also an attorney, but I am on the regulatory team. I primarily focus on kind of like all aspects of regulatory, but my kind of bread and butter are kind of quality issues, risk management, post-market surveillance, and then I do a lot of work with firms on their clinical trials as well.
Thank you. Yeah, we have a great team with varied experiences, varied skill sets, and it's been a pleasure the last 2 years. As you can see, our agenda here, we've already introduced ourselves, so we're good there. But we are going to start off with a bit of an FDA update that kind of sets the stage. Then this is really a panel conversation. As part of that conversation, we invite questions in real time as they come up. And we'll answer them as best we can. If it's too specific, always we'll have to punt on that. But I'm certainly looking to see all of our experience, right? Some of the best conversations I have in these meetings are where other people's experiences are brought in, because everyone in industry can learn from each other and kind of grow as we adapt to a changing FDA. And then we'll still have time for questions as well from the audience. So we'll make sure we hold time if you're a little bit shy of interrupting. So the past year at FDA, year and a half, has been interesting if you work with FDA. And I think when you look at change and you look at different individuals, you look at different skill sets, that can create challenges. So what just happened a couple of days ago, right? Dr. Macri, he is no longer at FDA, right? And so with that and the initiatives that he was leading, is there a question mark? And I think that you look right now, there's an acting, I had to write down the name, Kyle Diamantis is the acting director. And I think it was yesterday that FDA announced and HHS announced that they'll be doing a full search for a replacement. And so that tells you that, yep, the acting director will be short or long, right? Depends on the process and the confirmation that's required. But the individual currently leading the FDA doesn't really have a lot of medical experience. They came from private practice. They were at Jones Day. They actually did some defense work on infant formula, which is interesting because certainly FDA experience there, but not what you would typically see in an FDA commissioner. So I think that that's interesting. If it's going to be short term, it might not be that impactful, but it's still something to watch. That individual, Kyle, came from a food focus, right? He was leading FDA's food center and focused on some of the MAHA considerations, and so certainly has been at the center for a little while. I work a lot with CDRH. We work a lot with CDRH, and I will note that Dr. Michelle Tarver is still the lead at CDRH and has been from the previous administration. Actually, she was in Minnesota a few weeks ago. If you were at the Medical Alley event, I was at that. It was really great to hear her. I do appreciate the consistency that she brings. I think it gives a little bit of comfort, though even Dr. Tarver will acknowledge there's some shortcomings with just the resource load and some of the loss of knowledge they have, right? So great leadership update to provide for CDRH because it's nice to hear consistency. CBER, this is another acting leader, Dr. Sarama. I had to look it up online today to make sure I was saying it right. She's May 1st appointed, right? So this is very new. This is another acting. Dr. Prasad, who was there before, was there, left, came back. So a little bit of uncertainty when you're looking at CBER. Obviously, they control vaccines, biologics, the approval process for those. And so something to watch if you're in that space. And then Dr. Hogue is an acting director at CDER as well, a physician, didn't have regulatory experience, but certainly has the scientific chops. And so at those agencies, at those centers, I should say, there's a lot of different issues that they're facing, right? CDER and CBER, loss of talent, CDRH. You'll see it sometimes in the way that they respond to things. You won't get as full of a response, or you'll get what I might deem a deficient response from FDA as, hey, they're telling me there's an issue with this. I don't really see the issue. And to me, reading between the lines is the issue is you didn't have the time to maybe look at the full submission or the time to look at our answer. And so, when you see those kind of considerations and you see that with leadership updates and some of the firing and the rehiring that occurred, it is a tumultuous time at FDA. And I think it's important to acknowledge that when you are going to be in front of something, you need to know that you may not be dealing with the expert that was there 2 years ago who had been there for 20 years. Anything to add on that?
I'll add to that. So our team in March went to MDMA and we got to hear from a lot of FDA staff, and it was very clear to us that the times right now are more volatile, that it weighed heavy on them. They're still trying to meet their timelines, but we could see amongst the staff that that some of them mentioned that timelines are getting tougher, and so that volatility, I think that there might be more of that on the horizon potentially.
Yeah, great. Thank you. So, one thing when you're working with an agency, you're often interested most in what are they focusing on, right? Because what the FDA focuses on is what you should focus on, especially from an enforcement standpoint. I think one thing that stands out is advertising, especially DTC advertising. Rebecca's probably going to touch on this in a little bit, but I will note that that is a major area of enforcement right now, right? And so when you are putting your advertising out into social media, it's clearly discoverable if there are AI bots trolling, right? That's an easy way for FDA to find something. I think something I found interesting recently was FDA's focus on clinicaltrials.gov reporting. And there's a lot of consideration sometimes for companies who maybe don't want to report because maybe they didn't get what they wanted, right? So the results aren't great, or there's some reason that they're keeping something back. And now the FDA is saying, no, you've got to report as necessary. There's a lot of tools that they have. There's forms you have to sign, and you know, that could be misleading. It can ultimately become criminal, right? If you have to sign on a form and attest that you followed a process and you actually haven't. Will it actually become criminal? I don't know, but you can see the slippery slope that comes with some of these non-reporting scenarios, and FDA is now focusing on it. I also think some of the audit considerations are interesting. You know, unannounced, really a foreign focus. And when you are working with foreign entities, you have to understand some of the risks you might be taking. You know, there was a lot of consideration the last couple of years on foreign testing houses and some of the issues that FDA was finding there. And so that's not just like a new enforcement trend, but that's an increasing trend of, you know, making sure you understand who you're working with out in the space. And then real quick, a couple more thoughts on enforcement. It has come to our attention letters. You know, they were rarely used for a long time. In the last couple of years, I have seen a lot of them. And what they are is a very easy enforcement light type tool. I call it enforcement light from an FDA perspective, because you can send it out and you can not put a ton of work in if you're FDA, but you can make a company do a whole lot of work, right? You're gonna, whether you get a warning letter, an untitled letter, an ICTOA letter, as I call them, you're still gonna respond in kind, you know, 95% of the time. We had a question earlier asking, what if we don't respond? So it seems like a few of us may not respond, but ultimately, most of us are gonna respond, and the resources and the person hours it takes to address all of that is really quite constraining. And so it's interesting to see FDA use that tool, because I think the amount of resources they pour in is limited, and the amount of resources industry has to put in to address it is great. So it's, you know, be on the lookout, and if you get one, really take it seriously. And then, you know, there's other areas of enforcement on medical device and pharma, and I don't know if, you know, Rebecca, if there's anything kind of from a state scenario to look out for.
Yeah, I mean, some of the states, you know, they require, you know, certain drug or device companies to have licenses to sell in their states. And we recently saw Mississippi changed their definition of how they define medical device with regards to who requires a license in the state. So they essentially captured a much larger group of products and companies. And so just being on alert for these changes to know how you can comply is important.
Thank you. And I'm sure Vivian could speak to too. There's a lot of infrastructure that goes into states and medical device and durable medical equipment, and they need the funds to be able to run those programs. And the way they get funds is licensing and other things, and they're not getting funds through enforcement. So, you know, it could always change that. If a state needs more funds, the way to get those funds is through licensure or other similar programs. Before we move on to the panel, a couple more thoughts. You know, FDA programs to spur innovation. You know, the first 10, 15 minutes, you know, there's a little bit of a, maybe negative's the right word, but a little bit of a, you know, there's some issues at FDA, and FDA acknowledges those issues, but there's also some unique opportunities at FDA, and it's always good to see what's out there. You know, FDA's programs to spur innovation really are important to be aware of and to take action on if you can. You know, well, part of this is partnership with CMS, and that's really important, right? It's great to get a product to market quicker, but if no one's paying for it, you know, what does that give you ultimately? So a thoughtful partnership with CMS to make sure that quicker paths to market also come with quicker reimbursement options. So the MPV, the Priority Voucher Program, which was you know, the old commissioner's program, we'll see how that continues, but that was a unique idea to try to get review timelines on new drugs down significantly, as long as you had certain readiness in your program. And so that's a unique way to spur innovation. I know there was a little bit of controversy on how that was rolled out and who ultimately made the decisions for what was accepted, but it's certainly a bit of a template for other programs to say, okay, are there certain things that we can still get a full review, but do it in 10 months less, right? Because that's a lot of patients who could be helped in 10 months. The READY program, this is a unique program. It's actually recently rolled out. And it's about innovation in reducing hospitalizations. A lot of it is really focused on rural, but certainly you can see it would play out anywhere across the country. And it's, do you have something that deals with a chronic illness, something that when a patient is discharged and they go home, you've got an opportunity to get something in that home that can maybe reduce readministrations in the hospital, which are a great burden, a great expense. And so something there that FDA is just rolling out. I think they're actually accepting until September, they're accepting submissions on whether you could be accepted in it. So people out there with ideas, it would be a great time to think if that might fit. It kind of gives you a breakthrough type pathway right now, more touch points with FDA. And then the Tempo program it's a digital health focused program. This is really, a lot of the last couple are CDRH focused, a digital health program that's about chronic disease, and it's, ability to market your device without full pre-market authorization. And so there's some post-market requirements to make sure that you're meeting efficacy, safety considerations. I think this was March, some of the submissions were reviewed. And so, will be interesting to see what comes out of that. And then one that I like to point out is kind of a small change, a small pilot. It's a clarification on meeting minutes pilot, but I think it can be a huge of interest to industry to say, okay, I've got one more issue. Can I use this pilot program? Can I refer to this for FDA to kind of give me a follow-up and maybe save an additional pre-sub and maybe save 60, 75 days? I think that's a unique way of FDA saying, okay, can we limit it to one question or one kind of relatable question and maybe give a little bit more feedback to industry while not slowing them down too much. So real quick, looking ahead, I want to be done talking now. We're going to focus on my colleagues here. What do you see with FDA? What are you looking for from an FDA perspective, thinking about the things we've discussed here, some of the leadership changes, and kind of try to read the tea leaves if you can. Whomever.
I'll go first. I think with some of, there's been so many changes in the FDA, especially in the last couple of years. I think we're going to kind of hope for consistency. I know that there's been, I'm going to talk about it a little bit later too, but like with the QMSR rollout, there's a whole new inspection procedure that FDA's inspectors are now following. I'm hoping that we're going to see consistency going forward because that was a big program to roll out, and it's already, there's already a little bit of anticipation around that and anxiety around that. So I just want to make sure that once we have these changes or these changes with the FDA leadership and as we go through those, I kind of hope they stick to some of the old programs and make sure that they keep those consistent.
To add on to that, I think that speed and innovation and public trust, I think those are some kind of tag words that were floating around in my head when I knew we were going to talk about kind of what's on the horizon for the FDA. And I think the FDA is charged with making these science-based decisions and balancing that, and finding the right balance has always been a challenge. But I think particularly when there is this political pressure and judicial review of decisions, I think that adds to the pressure. But I will also be hopeful, like Bryn, that we'll see a little less volatility.
I will agree with that, but I will also add, it's just so important to remain on alert. The ground is, shifting, and it can shift at any moment, especially for those who kind of operate in more regulatory gray areas. They need to be aware of any potential changes. I'll speak more about this soon, but I do expect us to see more enforcement and potentially some rulemaking on direct-to-consumer advertising. I think there is a lot of change that could still come.
Yeah, thank you. Great. So I got some questions for you, and I think these are questions that really kind of set the stage of what we're talking about. So Bryn, the first one's up for you. How can companies leverage their experience under the quality system regulation to prepare for, but also importantly, succeed under the FDA's new quality management system regulation?
So I think a lot of the changes that came through, so QMSR is a big change. I was in my own home office, but I did let out a little audible gasp on February 2nd when I opened up the regulation and it was all gone. I was like, oh, my old friend. But for folks that have worked in the industry for a while, folks that have worked at global manufacturing companies, ISO 1345 is very familiar to you. So I'm hoping that you can leverage any of your previous knowledge working with that standard, and even any of your previous knowledge kind of working with the old QSR regulation to kind of bring you forward into the new QMSR. A lot of the ideas and concepts are very similar, so it should be a fairly easy transition, even if you're not familiar with the 1345 standard. I think kind of like the biggest piece that I'm sort of looking forward to is the integration of more of the risk management piece within the quality system regulation. I know that can make some folks a little apprehensive just because it is now sprinkled throughout the entire regulation instead of kind of just hidden away there in that design validation piece. But I think it's a very welcome change because I think historically the FDA was already kind of emphasizing risk management based approaches for everything. It just was not, it was not in the regulation as explicitly as it is now. So I think that will really help organizations as they move forward to kind of, keep that in the back of your mind. And if you're a person like me who kind of opens up that standard and opens up that regulation like most days of the week, you'll see that written out there. So it'll be a good reminder for folks just to kind of keep that in mind. Because I know that as the FDA does kind of do additional enforcement, that is one thing that they are continuing to emphasize is risk management, along with kind of the other kind of main areas of focus. There hasn't been a real change that I've seen as far as with this QMSR transition, showing that the FDA is moving away from things like CAPA, from post-market surveillance. They're still emphasizing kind of the same things. And even with the new inspection methods, it's still kind of getting the same topics, same things are getting flagged. The one thing though I think manufacturers need to be aware of is as we're kind of in the middle of this, a lot of these FDA inspections where now folks are getting warning letters, were done under the QSR. And so now the FDA though is expecting when you're, if you're putting a CAPA in place, for example, to do some corrections based on that warning letter, that now needs to be under the QMSR. You can't rely on the old methods anymore. So I think that the industry does need to be aware of that going forward, or it'll be a little bit difficult to manage in the new landscape. So.
Yeah, great. Thank you, Bryn. Daria, how do you see FDA's approach to AI and enabled medical devices evolving, and how should companies be positioning themselves now?
So I come at this from obviously the regulatory group where we do submission work, we do post-market surveillance. And so I sort of think about AI and I made a list of things, of issues that I foresee. And ultimately, I think because performance can evolve based on real world use, I'm seeing more of a focus on devices that have AI capabilities of some kind. I'm seeing that there's a higher burden of post-market surveillance, post-market activities that are reportable to the FDA. So I think that the FDA is sort of shifting to evaluating AI from a life cycle perspective rather than just kind of a static perspective. So that's one big shift. I think the key issue is really real world reliability, making sure that, when you test AI, in a perfect study setting, that's going to obviously yield certain results, but in real world, what will that look like? So I think that's, one major aspect that we're seeing in submission world, but also post-market surveillance. AI is also kind of being treated more and more by the FDA as a part of, as part of the quality system. And so that's another consideration. Bryn, I'm sure you'll see a lot of that.
Very excited about that. Not my fault.
I figured this much. And then I think post-market monitoring just is we're going to see a drastic increase. So I think those are some of the kind of hot topics within AI. The static product aspect, I think, is changing. It's no longer, we're seeing these approvals or clearances on a static product or an algorithm. It's a living, breathing device now, and I think the FDA is trying to address that and evolve with it as AI kind of shifts the landscape. So.
Yeah, interesting, and it's great. Everyone wants to incorporate AI, and they've got to understand what that means.
For sure.
Another thing people love to incorporate is direct-to-consumer advertising. Rebecca, what do you think the future holds? And I know this might be really specific to pharma as well as the medical device.
Yeah, so we have continued to see a lot of enforcement in the direct-to-consumer advertising space. Since September 2025, when FDA issued a statement that they were going to be focusing on direct-to-consumer advertising, we have seen a surge of letters regarding that. Back in September, FDA also mentioned in that same statement that they had plans to initiate rulemaking to revise the adequate provision requirement, or they called loophole. Essentially, they want companies to include all of the risk information for a drug right there in the direct-to-consumer advertisement. Right now, they are able to just have a brief statement of the major risks. So while we haven't seen FDA initiate rulemaking in this area yet, they want to make clear that they have not forgotten about the direct-to-consumer advertisements, and we've seen a lot of letters focusing on a variety of issues in these ads. You know, they can span from the proper balance of risk to benefit information, data portrayal, whether the risk information is adequate, all sorts of issues. You know, people kind of joke about, you know, sometimes they see drug commercials on TV and people are like, why are they singing and dancing while they're listing horrible side effects? And you know, FDA is not immune to that. And so they are cracking down on some of these audio and visuals and, you know, saying this could be misleading. And there was one letter I read where FDA noted that in several parts of the commercial, the product, which was a nasal spray, didn't have its cap. And part of the commercial was showing how easy it is to bring places. And FDA flagged that and said in the prescribing information, it says it needs to stay in the blister cap so it doesn't accidentally spray before the customer needs to use it. So they flagged that and said, you need to revise that. So they are looking and they want people to be aware that this is still on their radar. I wanted to mention there's also been some talk within the last month from a couple of senators who are actually urging FDA to essentially require pre-review of direct-to-consumer drug TV advertisements before they air in order to kind of cure this post-viewing sort of enforcement. And this could be a possibility. I want to mention FDA does already have authority to implement rulemaking in this space, but that same statute also does at the same time limit their ability to compel the sponsor to actually adopt their changes that they recommend. So I think we'll have to see what happens in this space, but we should be aware that it is very much on FDA's radar.
Great reminder. Thank you. You know, clinical trials can make or break a company, make or break their future, right? They're extremely important. For Bryn, how can prior FDA clinical and regulatory experience inform a more efficient and compliant clinical trial strategy?
So this is kind of similar in the same vein as QMSR. There hasn't been like a big shift in the regulation or anything like that for clinical trials, but the FDA is continuing to focus on some of the same things that they are with QMSR compliance, mainly being that we are now, you know, seeing a lot more global clinical trials. A lot of sponsors are using CROs. The FDA has been cracking down a little bit more on ensuring that sponsors aren't passing off their responsibility to that CRO and that sponsors are bringing on that CRO, you know, having appropriate supply agreements and oversight over that CRO. So the FDA still has been continuing to emphasize that sponsors do need to take responsibility for their you know, their contractors and everything like that. Same as any kind of manufacturer would need to take control of their suppliers as well. So there's also been a continuing emphasis with the FDA for clinical trials on risk. Again, it's similar to how they've been emphasizing that with QMSR compliance. They are looking to sponsors to make sure they're making risk-based decisions, making sure that they're doing their appropriate and it's you know, appropriate regulatory reporting for adverse events. That's another big one I'm seeing out of clinical trials that folks need to continue to watch out for. Should be doing already, but continuing to make sure that they're focusing on those areas.
Yeah, great. Thank you. Daria, I feel like cybersecurity is becoming like biocompatibility, where there's always going to be something. You think you have all your ducks in a row and you're missing 40 of them. So how is that changing FDA expectations, and what are companies still getting wrong when it comes to cybersecurity?
So I think that there's a lot of unpredictability around cybersecurity. I think that, you know, a lot of the testing houses, there's been a lot of sort of unpredictability with what's expected from the FDA. So I think that there's probably more to come, because I'm seeing more and more clients having these issues about cybersecurity. But I think the biggest part to consider is that cybersecurity is really becoming a part of the safety and effectiveness of a device. Ultimately, it's not just a a hacking incident or, a data breach. A lot of times now it affects the functionality of a device. And so you can have situations where maybe a defibrillator doesn't defibrillate, and you can see how that can create safety issues for patients. So that's one aspect. I think the other aspect is, companies really need to start thinking about cybersecurity from the start. I think the FDA is getting very good at identifying when a company kind of considered cybersecurity as an afterthought and sort of layered and patched it on, instead of thinking about it from the start, before you even submit, when you submit and after you submit. So I think that that's another aspect. And then I think during the submission process, what I'm seeing is the FDA doesn't want to hear things like, oh, we're using, industry best practices here. They want to know in very real terms, what are you doing to mitigate risk? What are the risks that you see with your specific device, and how are you going to mitigate those? So.
Yeah, no, great. Rebecca, I think GLP-1s are an interesting case study, right? Because of the just astronomical growth in the use of them, right? They're everywhere. They're not just the big prescriptions that you see on TV. A lot of compounding pharmacies are getting, involved with them. There's a lot of different ideas around products to help people find GLP-1s and all these things. How has FDA responded to this increase in GLP-1 use and just the fact that it's everywhere now in many different iterations?
Yeah, no, this is very, very prevalent right now. FDA is very much aware of, what's going on in this space. So these GLP-1s, there are some that are FDA approved. Others are more operating in the compounding space because they were for a time on the national drug shortage list. So they had authority to be compounded for this mass use. Typically drugs are compounded, when there's a shortage, or if a patient has an individual need that the FDA approved version cannot take care of on its own. So there was a time where they were operating in this space. However, they are no longer on the national drug shortage list. But obviously there is still so much use of it right now. So FDA is operating in steps. So as of right now, FDA has been sending some letters to these telehealth companies, basically saying, a lot of your material is not okay. You're basically comparing your compounded drug to the FDA approved version, which is not okay. This comparative messaging essentially could mislead consumers into thinking that these compounded drugs are FDA approved when they're not. They haven't been tested for the same safety, effectiveness, and quality as an FDA approved drug would. So they're kind of coming at it from that angle. They're also sending some letters as well to the companies who have FDA approved drugs for claims about superiority and enhanced efficacy that just are not adequate, that are inadequately supported. So FDA is aware, and I believe they're going to just operate in strides and go about this a little bit slowly. But I guess we'll have to see what happens.
Yeah, thank you. That kind of goes to peptides in general, right? We could probably have another 30 minutes just on that, and ways to navigate FDA. But I really appreciate your insight today and kind of what you've learned and where companies can go from here. I know we've got about a couple minutes left of our panel time, so if there are any questions, happy to address them.
Yeah, there's a couple online. First one is, so Rick Abramson joined the agency as the head of Digital Health Center of Excellence in February. Any potential impacts on that you've heard? He was most recently an exec at an AI imaging company.
Yeah, I was in a meeting with him a few weeks ago, actually, and right now he said he's in learning mode. So I think there's more to come. I think it's great that he's in learning mode because he brings experience from industry, and he kind of brings experience of, okay, here's what my struggles have been. And when someone at the agency understands the struggles and they have now some power to impact those, how much from that position we'll see. But I think that that's great. So certainly more to come, but I really liked what I saw, and I liked the way that he was approaching his initial time at the agency.
All right, this is probably for Bryn. Will FDA now recognize an ISO 13485 certificate?
I don't see that happening in the near future. They have very specifically said no right now. I think eventually that seems like the logical thing to do, but it does feel a little bit like that's kind of not the FDA's normal, way that they operate, where there already is like the MDSAP program, and the FDA is still not kind of giving full reins to that either. So I don't see it, I guess, in the near future, but potentially someday.
All right, thank you all for your time.
Hello. Okay. Great. That was awesome. Very, very cool. There's a lot going on with FDA. Do we want to? That works. All right. We are going to talk about compliance now. My name is Maina Johnson again. I'd like to introduce you to my panel members, my fellow presenters here. I'll just quickly introduce them just so we can get into content. But Lisa Damhoff is to my left. She's an associate attorney on the compliance team, helps with compliance programs, contracts, some regulatory stuff. She brings prior in-house experience from Coloplast. And then we have Jake Leese, who is a couple months in, I think, right? Also an associate attorney on the compliance team. Compliance, regulatory, a little bit of privacy, a little bit of everything. Brings previous in-house experience from Edwards Life Sciences, and also prior private practice experience from Ropes and Gray. So we have a good kind of mix of experiences here. All right. So the agenda today, we're going to try to keep it conversational, kind of as keeping with the theme. I'm going to talk about False Claims Act recovery trends just over the last 10 years and kind of where things are headed. And then we have 3 focused risk conversations that we've picked some topics that come up often with clients that have some kind of thorny risk issues that come up. So we'll each talk a little bit about a focused conversation there, and then we'll have time for questions. And feel free to interrupt us if you have questions as we go. All right, this is a little bit of an eye chart. It's actually pared down from the actual DOJ's fact sheet, but I wanted to talk about a few key trends. So this is False Claims Act recovery, dollars, numbers over the last 10 years. And just wanted to mention just a few metrics here. So the first is key TAM matters, new key TAM matters, and that's the graph on the bottom left, just to show you kind of what it's looked like. This is the main driver as of the last couple of years in terms of False Claims Act recoveries. We've seen a drastic increase in the last couple of years. As you can see, it's been relatively flat for the last 10 years, or the last 8 prior years, and then it's shot up. That's very interesting and kind of aligns with what we've been talking about today. But I think that's a very strong signal. And I think there's a couple reasons that we could guess as to why we're seeing such an increase there. First of all, I think there's some strong programs that the DOJ and the OIG have rolled out regarding encouraging whistleblowing and raising your hand for the government. I think we increasingly have people that are willing to raise their hand and go to the government. And I think another element of that is probably just the evolution of our interconnected, kind of more visibility across the organization. We're using tools and portals and CRMs and more people across the organization that can see what's going on within the company. So I think there's an aspect of that is just we have more touch points. We have more people seeing what's going on in the company, and that is additional entry points for scrutiny. The second metric I want to point out is the non-key TAM matters. So it's this third column, but I don't have a graph for it. It's remained relatively flat. It's about 400, 300 over the last few years. To me, that shows that the government is just continuing to be selective about cases that they bring on their own, and they're relying heavily on whistleblowers to bring them cases. Raise your hand and bring them cases. The third is the declined key TAM recoveries. So we talked a little bit about this with Vivian, but the DOJ can decline to intervene or they can choose to intervene. And what's interesting is that we continue to see really high dollar amounts for recoveries for declined key TAM. So this is where the government, starts to look at it, does some investigation, and decides just, we're good. We'll let the plaintiff bar continue. That last year it was $2.3 billion. That's a third of the total False Claims Act recoveries. So that means the government didn't even have to do much for those, and they're getting 33% of their $6.8 billion. And then the last metric is the total False Claims Act recoveries. So that's the far right bottom bar graph and the far right column. Last year we had a record year, $6.9 billion. But you can see there's not really a trend line over the last 10 years. It's kind of popping up and down. And I think that shows just a little bit of volatility in terms of DOJ resources, maybe the political environment, the administration changes, maybe just how the industry is changing and evolving. But it's interesting that it's kind of popping up and down, and we haven't seen, yes, we had a record year last year, but it isn't clearly going up and down. It kind of pops around. And if you look at the cases, unfortunately, the DOJ doesn't break out False Claims Act by device, pharma, healthcare, that kind of a thing. But 84% of all the False Claims Act recoveries were from healthcare. So they are clearly focused on healthcare. They're going to continue to do that. But if we look at a sampling of the cases from the last 10 years, one of the observations that I wanted to bring up was just we're seeing more operational risk. So companies may have mature compliance programs. They may have, great compliance policies. They may do a good job of putting together commercial programs to mitigate risk, but they may not be operationalized that way in practice. And that's where I think we're seeing some of these cases. We're still seeing a lot of the garden variety fraud and kind of the egregious statements and egregious behavior cases, but a lot more are cases built on patterns, cases built on sales metrics or dashboards or internal communications and meeting minutes, like if recording they may have had, perfectly compliant, documents outlining what they were doing, but the government has to look a little deeper to see kind of what the intent was. So I think we're seeing, more importance going forward on making sure you have the right policy in place, but also making sure that you're operationalizing the program or whatever practice and making sure that you're actually complying with the policy. We talked a little bit about more discoverable evidence. I think the more data-driven, the more interconnected our companies are becoming, the more opportunity we have for creating evidence, metrics, emails, text messages, recordings, AI transcripts, all that stuff. And so I think that does also contribute to the increase in the whistleblower risks that we're seeing as well. All right, so that was just my kind of quick primer on the False Claims Act trends that we're seeing. And I'm going to hand it over to Lisa. She's going to do a focused risk discussion on pricing and discount.
Oh boy. All right. Okay, so building on that slide on the FCA trends and specifically the increase in the key TAM cases, we're going to talk a little bit about the evolution of pricing and discount risk. And AKS violations, which can include improper discounting and pricing practices, they often serve as predicates for FCA liability. And we haven't really seen a whole lot from the government specifically with regard to discounting and pricing violations in terms of AKS risk over the last decade, but we're seeing some hints of that changing just with some things that the government's communicating. And more recently, the AKS enforcement seems to be focused not necessarily on whether discounts exist. The government is generally okay with discounting, and we'll talk about that in a little bit, but more so focused specifically on how those pricing incentives are actually structured. So what does it look like when they're structured, when they're rolled out in the real world? The OIG's advisory opinion 2511, which came out in December 2025, provides some insight. It definitely is not all new information, but it does give us a little insight into what the government is thinking more recently. Always strive to have your discount structures fit nicely and neatly within the discount safe harbor. But if they don't fit squarely within the discount safe harbor, be able to demonstrate sufficiently low risk of fraud and abuse to avoid enforcement. And again, that's not necessarily new, but the opinion does reflect more flexibility in how that's accomplished. And so the government is telling us that they're open to a range of discount models. And the requester in that advisory opinion specifically asked the government about a variety of arrangements that they had set up, and they were seeking input from the government on. And those included upfront discounts, volume-based pricing, tiered discounts, certain bundled discounts and rebates. And the government found that while not all of them fit squarely within the discount safe harbor, they were sufficiently low risk of fraud and abuse. And so ultimately the government is telling us they're okay with a variety of these models. And something worth noting too, that again is not necessarily new. The opinion indicates that pricing flexibility is not only okay, but the government also recognizes some of the benefits to government programs and to consumers and customers, which obviously there's lower costs with discounts, and it ultimately increases competition in the market. So when we're thinking about discounts and how you're going to set them up at your companies, the biggest thing is to focus on compliance considerations from the get-go. I think some problems can arise when companies and teams and sales are working with customers and they want to start talking to customers about all these creative options, and they forget to involve legal and compliance right away. Sometimes it's an afterthought, and that's when legal has to be the bad guy and come in and kind of put the reins on things. So involving your compliance and legal teams right away up front is step number one. But when we're actually rolling them out, risk is really created when the model isn't transparent. So customers need to be able to report the net cost of the price they paid for their product to the government. And if they can't do that, that's when we're not transparent, that's when risk arises. So situations, just some examples, discounts that might be tied to services or non-product benefits rather than pure price reductions. It gets tricky to figure out what part of the price covered a service, what part of the price covered the product. If you can't determine that, then that's when the government's not going to like that structure. Another example would be bundled discounts across products that aren't reimbursed under the same methodology or under the same federal programs. So that could ultimately distort the pricing of all the products that are included in the bundle. And interestingly, there were a couple of the arrangements in the advisory opinion 2511 that were bundled discounts across different methodology, or that were reimbursed under different methodologies, and the government was okay with them because they were sufficiently low risk. And you can have some light reading later and read that opinion as to why that was. But I think that was a little surprising that the government was okay with some of that creativity. And finally, just ultimately, you need to make sure that you're providing your customer with enough information in order for them to accurately report the discount amount. That seems like a very simple statement, but again, operationalizing that and putting that into practice is very important. So transparency is a key, number one, that we take away from the government's opinion there. And the second thing, operationalizing, like Amanda talked about. Think about the logistics of your company. Think about the company, the teams that you have in place, who's all working together in order to actually put this discount structure into practice. A lot of times, I think I mentioned it a second ago, teams get really excited about the creative model that they came up with, and then I say to clients right away, can you implement this? Like, this is great, but can you implement it? And then everyone kind of stops. And so again, taking that step back and making sure that you can actually implement the lovely structure that you just came up with. Again, looking into the future a little bit and what the government is thinking, the DOJ HHS False Claims Act Working Group also issued a press release in July 2025. And as part of the working group's coordination work, HHS is going to be making referrals to DOJ of potential violations of the False Claims Act that reflect the working group priorities. And in that press release, the working group specifically mentioned a priority enforcement area to be drug, device, or biologics pricing, including discount and rebate structures. So further building on Amanda's slide on key TAM cases, that press release specifically stated that the working group encourages whistleblowers to identify and report violations of the False Claims Act that they're seeing and that involve the priority enforcement areas. So the government really is paying attention. Again, there hasn't been the government has been a little bit quiet over the last decade, but they're really putting out there that they're thinking about it. Okay, there's a question?
Question online. What does reimbursed under the same methodology mean in practice?
So that is a great question, and a lot of research has gone into that. I mean, when you think about it, different types of products, if you have an implantable versus a disposable, are products included in one procedure? Are they under the same reimbursement code? There could be different things that go into it.
Right. Procedural codes, whether it's inpatient, outpatient. We would have to look at the facts to determine whether it would be reimbursed under the same methodology. We don't have a ton of guidance from the government on what that means either.
Yeah, we smile about that because this question has come up.
It was well defined, but I mean, there is a list of different types of methodologies that you would look at and try to craft an argument as to why it would fit under the same methodology.
Yeah.
I actually have a quick question as well. So you talked a lot about operationalizing in current state right now. With the trends that you've seen, do you have anything to keep at the forefront for companies that are designing discount programs in the decade ahead?
Yeah, so keep coming up with the discount structures. It's okay to think creatively a little bit. Don't get too creative. I don't know that the government is wanting that, but we're definitely seeing that the government is okay with some flexibility and some creativity. But like I mentioned before, keep your legal and compliance teams involved at the forefront. From the get-go, get them involved, and make sure that you're weaving compliance considerations into the terms of your discount models. So again, transparency, be clear, make sure that it's product specific. Both the customer and the company are aware of what's going into the model, and just ultimately making sure that the customer is able to report that net cost of the product or the price that it paid. And then operationalizing, just making sure that everybody knows what they're going to be doing in order to actually implement that model.
All right. Thank you, Lisa. And we're going to switch to talk about speaker programs. Speaking of things that the government is kind of quiet on, that is not one of them. So we will look a little bit at the last 10 years and going forward on speaker programs.
Yeah, thank you for that. Tough acts to follow, but yeah, looking at the changing landscape of speaker programs over the last decade, certainly the government has given us quite a bit of guidance here. So let's start by rolling back the clock one decade, right? Let's go back to 2016, which was a surprise to me. It's not 2006. So back in 2016, if we looked around, I think you'd see a very different compliance state as it pertains to HCP or healthcare professional interactions as opposed to what we see today. Well, why is that? As many of you in this room may recall, we had a bit of an inflection point in 2020. This was punctuated with the OIG 2020 special fraud alert on speaker programs. But it's important to understand a little bit of the context that went into that. So first off, one estimate I found was that in the 3 years leading up to this fraud alert, it was estimated that the pharmaceutical and medical device manufacturers had spent somewhere in the area of about $2 billion on speaker honoraria and other things that could be characterized as HCP remuneration. This was, again, earlier in 2020, preceding this, the speaker program, there was a large settlement with Novartis to settle allegations of exactly this, that there was some level of speaker honorarias and inappropriate luxury venues and things that could be characterized as inappropriate remuneration. They settled for a pretty small amount, something to the tune of $640 million. So
peanuts.
Yeah, peanuts. So that was sort of the first shot that, okay, we're going to start to care a lot more about these activities that maybe are not prevalent in the industry, but were more common then than now. And arguably, it looked like when the OIG put out this fraud alert, they used a lot of that settlement case as a blueprint to show exactly what the intent can be behind these speaker and educational programs. In essence, they said that we no longer care what you're calling these programs per se, but it goes to what's actually happening in practice. How is it operationalized and what's the underlying intent? And to get at that, they listed or enumerated a number of suspect characteristics. I have them here on the PowerPoint. This is not a fully inclusive list. There's certainly more in the fraud alert, and I encourage you to read it if you have not. It still holds up. But they said that none of these characteristics are by themselves dispositive, but they do speak to the underlying intent when investigators are scrutinizing you. It includes the availability of alcohol. That risk is heightened if it's provided free. What the purpose of the venue is. Is it for entertainment principally, or is it to facilitate education? Right? Is it proximate and convenient location to the attendees and speakers? Is the topic repeated, or is there actual novel educational value? Do the attendees at these programs have a legitimate need to hear it, or is it going to be an HCP's spouse who's not in the industry who has come along with them? And of course, if the sales and marketing teams have influence over these programs, selecting speakers, selecting attendees, all of these things can heighten the risk. And so let's then fast forward to current state or near current state in 2025. So we saw that the OIG had planted this flag saying these are concerns that we are going to start scrutinizing. They're going to be on the spotlight. And then we see in 2025, they followed through on that. So Gilead Sciences paid $202 million to settle allegations that their speaker programs used honoraria, travel, luxury venues to target their high prescribing HCPs with minimal educational value programs. And what do we learn from that? Well, we mirror exactly what was said in the fraud alert, that venue choice, repeat attendance, and prescriber targeting are treated as evidence of intent, like we were told they would be. And then let's go a little bit earlier. It's a slightly lesser number, but just a hair under $60 million paid by Pfizer. Now, this is an interesting one for a number of points, but what was alleged was that, again, high-end meals and speaker programs were allegedly used to induce prescribing here. And what's interesting here is that this was activity alleged to have been committed by Biohaven pre-acquisition by Pfizer. Then post-acquisition, Pfizer is still footing that bill. That might not be a big shock to anybody, but it's something to keep in mind as a practice pointer for doing diligence. This is functionally a liability that was on the books that who knows if Pfizer did or did not catch it, but they're the ones that paid the bill. And then keeping in line with our actual lesson here, we see that repeat attendance and low educational value consistently and quickly convert the educational value of a program into inducement risk. So over the last decade, unlike our other topics that have perhaps been a little bit quiet and a little bit looking into the crystal ball, the government and the OIG said, we care about these issues. We are enforcing these issues. And so now today, we need to develop our compliance programs to not just be great paper programs, but to make sure that they are operationalized and have sufficient controls to make sure that we are actually doing what we say that we're doing and that we're complying with these concerns that could be prohibitive HCP remuneration.
Yeah, I remember being at a compliance conference. It was probably, I don't even know, fall of 24. And I remember somebody from the OIG saying there will be 2 settlements coming out related to speaker programs. So sure enough, they did. The question for you, so as we see enforcement continue in this space, where is the line practically, and how should companies operationalize the venue and meal selections in a way that DOJ would see as defensible going forward?
Yeah, no, great question. I don't think there's one particular bright line rule I would hang my hat on. One thing I would keep in mind, or a question I would ask, is what is the purpose of the venue, right? So if the purpose of the venue is primarily going to be entertainment, if it's going to be at a winery or a sports stadium, that looks more suspect to me than if it's going to be a grungy motel on the side of the highway, right? That might be a little bit better for actually facilitating educational programs. It's not, I think, necessarily that close of a call either. Like if we look at Gilead Sciences, the facts that were alleged there and settled were pretty egregious. For instance, for venue and meals, it was something to the effect of, I think they were frequently holding these programs at a high-end New York restaurant that was like a 5-course meal with alcohol pairings, and it was something to the effect of $500 per head to be there just for the food and beverage. So that's something that pretty clearly feels uncomfortable when you're looking at that from any other compliance or regulatory perspective. That said, that's the first point. That's what I'd keep in mind. And second, to reflect back what my colleagues here have said, an ounce of prevention is worth a pound of cure in these situations. You never want to be rationalizing or justifying your venue or meal choice looking in your rearview mirror after it's already happened, right? You want to have this memorialized and codified in your internal procedures. You want to have sufficient controls. You want to make sure it's your compliance, legal, regulatory, not sales and marketing, who are making these decisions, who are choosing the venue, who are selecting attendees. And you want to make sure you're following your procedures. So I think with that, if you keep that question in mind of what's the purpose and you make sure that your procedures are standing up to the snuff, it at least gives you the best chance of making sure that everything is appropriate and that the underlying intent is going to bear fruit.
Thank you. Yeah, I get questions still on venue, and it's somewhere between a grungy motel and a, resort area. So that's funny. All right. So our last compliance risk conversation is on reimbursement support, which just seems to be such a hot topic lately over the past year or so. And kind of along the lines of what we were talking about, what the government has been quiet, this is one area where we do not have a lot of direct guidance from the government. So I think companies struggle with it, which makes sense. So just to level set, when we're talking about reimbursement support, we're talking about a company or a manufacturer assisting with the benefits verification process, prior authorization, appeals, and then also providing coding and billing guidance on their products. This is very common for companies to do. The reimbursement landscape is complicated. There are real access barriers, and the company is really in the best position to be helping facilitate accurate billing and coding because they're the experts on the product. So the government has, kind of silently acknowledged that this is permissible to do. It's just where that line is in terms of when does it go too far? And from an enforcement landscape perspective, like I mentioned, we have really limited direct enforcement, no settlement. Nothing really directly on point from a reimbursement support program, especially for medical devices. We have a couple of cases in the pharma space on prior auth where, it really contained more kind of egregious facts where they were misstating, making false statements, modifying medical necessity documentation. So we kind of have that extreme, and then we have some kind of risk that has been inferred from adjacent AKS and FCA cases, mostly on the topic of manufacturer support programs, but not specifically reimbursement support programs. We have some comments from the Federal Register from, I think, 2001 that talk about, basically they say reimbursement support is not an inducement as long as it doesn't become an independent value to providers. And they don't really give us a lot of insight into what they mean by that. All that to say, we don't have a lot of guidance specifically on the topic of reimbursement support. So one of the questions we frequently get is, can you help us review our reimbursement support program and let us know if it's compliant? And that really is a very fact-specific question. And I'll also get questions on where's the line? Like, when does it become an inducement? And that's also a very loaded question. There are some things that drive risk that we know, and again, risk inferred from kind of adjacent cases. When the free services are too valuable and they start influencing prescribing or utilization, if the company is influencing reimbursement outcomes, so if they are, getting too involved in that process instead of just passing on information, if they start relieving providers or their office staff of, administrative burden, which again, a lot of this you could argue that it does indeed. And then steering, so steering patients, steering utilization decisions. So just some things that come up when it comes to risk. And when we talk about risks here, reimbursement support is in kind of a unique space because we have AKS risk, we have False Claims Act risk, we have FDA risk, and then we have privacy, security risk. From an FDA perspective, the FDA could take the perspective that if you're supporting off-label cases, that you are essentially promoting them off-label. From a privacy perspective, there's a lot of patient information being passed back and forth. You have to make sure you're set up appropriately, whether it's a business associate agreement or a patient authorization. And then from a False Claims Act perspective, companies don't want to be, facilitating false claims to be submitted to the government. So there's a lot of, it's the point of intersection of a lot of risk. So I totally get why companies, struggle with this space and are looking for guidance. And, we can do our best to glean kind of the risk inferred and guardrails from what we have, but there's really not to date, we haven't seen anything real specific on, like the speaker program. I wish we had something like that for the reimbursement space because they were pretty clear. From a mitigation perspective, I mean, there are things we obviously recommend. The big thing is operation. Again, kind of the theme of the day, designing the program well with controls, having clear boundaries between the reimbursement support function and then commercial. But again, when we're talking about this interconnected kind of data-driven environment that a lot of the companies are in today, we have to be diligent that we're not sharing that information across the business and that the reimbursement support information is kept kind of siloed from the commercial organization. And that's, again, kind of a safeguard. One interesting aspect that I've seen kind of over the last 10 years, I guess, is 10 years ago, I think companies weren't as mindful or weren't as strategic about designing for reimbursement. So that would, a lot of companies, and I don't fault them. I mean, I get it. You're working on your product, you're designing it, you're getting FDA, clearance, approval, and then you go out and sell and you realize you don't have any reimbursement. Nobody's going to buy it if it's not being reimbursed. So then you're kind of in a situation where you're scrambling and trying to be reactive in terms of trying to, fix things, and maybe you'll be a little bit more creative. So I do think in that respect, companies are being more proactive and mindful about it. So that might help reduce kind of the risk that these programs might become an inducement or might become a risk. On the other hand, if it's too intertwined with the commercialization strategy, that could create risk as well. If there's maybe metrics that are tied or visibility, across the company in terms of kind of where the risk points are. So I guess just all to say, this is very much a common topic that comes up. We have some guidance and we have some guesses as to what, the government really wants to see. But it'll be interesting to see kind of going forward how it's treated.
So if you had to predict, where is enforcement headed in this area over the next 10 years?
If I had to predict, I do think we'll see a little bit more direct enforcement action, or at least guidance, maybe. I would, if anyone wants to submit an advisory opinion on this topic, we'd be happy to help because I think it'd be really interesting. I think we will see some enforcement. I think it's going to be focused on data privacy, data flow, data sharing. I think that's going to be a piece of it. I think vendor oversight and kind of what the vendor's responsibilities are versus what the manufacturer's responsibilities are. We've seen a number of AI tools come out to help with like the prior auth process and appeals support. And that brings kind of a whole host of other, considerations. But I do think that piece, might come under scrutiny. And then I also think just the closer these types of programs are to the commercialization and the commercial team, I think sharing metrics, that kind of thing, I think that will be an area of scrutiny as well. Do we have any questions online or in the room? Nothing? Yeah, I will just add, I think the reimbursement support program piece, I think it's ripe for whistleblowing. I think it touches a lot of people in the company, both internal and external. If we're thinking of, market access, the executive leadership team on down, they're very interested in it because the sales depend on it, honestly. But then also externally. So we're having conversations with providers, their offices, patients. So there's a lot of people that know about the inner workings of these programs. And I think the more, that's more touch points and again, kind of more data points or entry points for scrutiny. So, yeah. Oh. Yeah.
All right. I'll speak loudly. It's a philosophical question.
Okay.
All right. So just a little bit of a philosophical question. Many years ago, I had dinner with one of the co-founders for LegalZoom, and he criticized our profession, saying that lawyers are always in the business of saying no. And I have a feeling that the lawyers in this room, that's exactly what our role is. So we're not criminal defense lawyers, most of us anyway, myself accepted. But we are always telling our counterparts in the business, no, this is why you can't do this, there's too much risk. And I think maybe we might be taken a little more seriously if we came to them with some solutions instead of just, no, you can't do that. And I wonder if you have any thoughts on how to engage with stakeholders in the business in a different way.
Yeah, I mean, I'll just say, I think a big part of being outside counsel and in our roles is really not saying no unless we absolutely have to. Being in-house, I think everybody at the firm has been in-house at a company, and I remember being called the sales prevention team at one point. So that is not our job. I mean, we want to inform you of the risk. We want to explain to you what the risks are, what could happen. But ultimately, it's up to the company to decide. I think that's one of the tenets is that we don't say no unless it truly is something that is a plain violation of the law. We can help provide guidance and guardrails on how to mitigate risk, but we're very used to saying here, there's the risk. If you want to proceed, here are some things that we would recommend, but they may mitigate, but it won't eliminate the risk. So I don't know if you guys have thoughts.
Yeah, I was just going to say, I think each one of us in our individual presentations said too, please involve legal and compliance from the get-go. We want to be involved in structuring a program so that doesn't happen where you're at a point where you're ready to run with it, or maybe even have presented it to a customer, and then all of a sudden it's we got to talk to legal. And at that point, sometimes the answer might be no, we can't, we have to dial back. So I know everyone on our team is very, loop us in from the beginning so we can help build the program in a compliant way.
Yeah, just to add my 2 cents, I couldn't agree more. To rephrase one of my favorite sayings is an ounce of prevention is worth a pound of cure. Bring us in early and we can help you get to yes. We can help educate. We can help decide what is your actual goal here, because there might be a more compliant or risk mitigation way to get there. That can be a bit more of a struggle. I know when I was in-house, it felt a lot more combative because it's hard to get looped in early and you're always you become the ones that can be an imposition to sales. And so we want to avoid that, whether you're in-house, whether you're outside counsel. So absolutely.
Yeah. No, good question. I like it. Yeah. All right. Thank you guys. That was great.
Thank you for those great sessions. We're going to take a quick break here in the room, and there's some liquid refreshments at the bar and some snacks behind the bar. And we'll get started in about 8 minutes, and we'll close with the privacy session and the GC panel.
Testing. Can you hear me all right? Perfect.
Testing as well. Oh, this is good.
All right, thank you, everybody. We will go ahead and get started to stay kind of on time here, so everyone can kind of wrap up at 4:15 as planned. All right, thank you. So why don't we go ahead and get started on some privacy topics. So we want to talk briefly today about some of the many trends continuing in privacy, AI, and cybersecurity enforcement. You'll hear a lot about privacy. That's where we're seeing a lot of enforcement right now that's been trending in a new direction, but we'll touch on some of these other areas as well. So just briefly about myself, my name is Paul Rothermel. I'm an attorney at Gardner Law. I'm at Gardner now about 5.5 years, along with Nate. And my focus in practice has been privacy, so HIPAA, GDPR, various state privacy laws that have become, a significant part of our practice and a part of compliance and privacy over time, and other privacy matters as well in cybersecurity, AI. I'll let Josh introduce himself.
Well, hello, my name is Josh Arculari. I am an associate attorney at Gardner Law, and I practice on the privacy team with Paul. My background is mostly in clinical research, where I spent the better part of a decade working with HIPAA and FDA regulations and global privacy regulations. Before joining Gardner a few months ago, I was on the R&D legal team of a biotech company, Regeneron Pharmaceuticals. And then before that, I worked for a few different hospital systems here in the US. I worked at the Minneapolis Heart Institute Foundation here in Minnesota. And then before that, or after that, I was at the Children's Hospital in Colorado.
Thanks, Josh. So we'll dive right in. So imagine, and keeping in mind, this is a topic today, a theme of 10 years. 10 years has gone by since Gardner Law was founded, but also let's time travel a little bit. The year is 2016. You just bought your brand new iPhone 7, and maybe you made your first order on the brand new mobile app for Starbucks to pick up. Seems like such a recent thing, but 10 years has gone by since all this has happened. So it is quite a bit of time in terms of technology and a very long time in terms of privacy law. Back in 2016, we were still talking a lot about HIPAA in terms of the primary enforcement area of this law, this area of law, and specifically we're concerned about the brand new two years out from the HITECH Act, which added specifically liability for business associates, not just the covered entity who could then go after the business associates separately, but directly those service providers could be under enforcement action from OCR and the federal government. State medical records laws still around, but they were a significant part of the privacy law landscape then. Children's Online Privacy and Protection Act, of course, the Section 5 of the FTC Act, and along with the Health Breach Notification Rule of 2009. So these various privacy enforcement mechanisms are available through these laws federally, and some state law, but not a significant part of privacy law other than some of these breach notification rules, and breach notification rules being, hey, something has happened and now we have to follow up with the subjects who are impacted. And the TCPA as well, which protects consumers essentially from unwanted texts or phone calls, those kinds of things. So now it's 2026, and Josh will fill us in on what's going on now.
Sure. So in 2026, as many of you probably know, privacy law is quite a bit more complex. In 2016, we were dealing with a handful of federal laws and a state law, governing medical records. But today we're dealing with this patchwork of state privacy laws. And California continues to lead the way with the California Consumer Protection Act and other laws and regulations in California. And in many ways, California created the model that many other states have created their comprehensive privacy programs from. And as you can see, now we're up to about 20 states with comprehensive state privacy programs that offer similar but not identical requirements. Mostly the similarities would include that the rights that they give consumers, such as the right to know the data that's collected about you from various websites, companies' websites and platforms. And then of course, like opt-out requests. Now we see cookie banners and things like that you didn't see so much 10 years ago. And we also have 3 states with consumer health data laws that, this is at the state level, but it does go beyond HIPAA and applies to health data more broadly than just PHI. And then there's a handful of states that have AI governance laws, like Texas and Colorado have their own separate statutes governing artificial intelligence. And then we have like automated decision-making being regulated, sort of baked into the CCPA. And then, well, finally, we have old laws being used in new ways under the, specifically in California, under the California Invasion of Privacy Act. That's a law that was enacted way back in 1967 to govern wiretapping. So the recording of inbound and outbound calls. And obviously that applied specifically to the telephone then, but now plaintiffs' attorneys in the US and particularly in California are using this old statute and applying it to online tracking technologies and specifically pixels. And Paul's going to talk a little bit about this tension that we see in California right now, where this old statute is being applied in new ways, and then the divide in the courts where some judges find that this statute does apply to online tracking technologies. Others find that it does not. So that's high-level overview of 2026. So going back in time now to 2016 and to talk a little bit about the enforcement landscape. So cybersecurity failures and breaches were very active in 2016, particularly through the FTC. The FTC was using its authority under Section 5 of the FTC Act to govern and police unfair and deceptive trade practices. And in particular, companies are expected to implement what the FTC describes as reasonable security controls. So things like encryption and access management and having policies and procedures in place to respond to breaches. And increasingly, regulators were treating a breach not as an unavoidable event, but as perhaps an indicator that those reasonable security controls that the FTC requires were missing. And then inaccurate privacy policies. So something we might call truth in statements, where it's relevant in 2016 and relevant today, where companies should say what they do and do what they say in their privacy policies to avoid enforcement. And we'll talk about some specific cases involving inaccurate privacy policies as well. And then in 2016, HIPAA. HIPAA enforcement was also very active. It was a particularly big year for HIPAA enforcement. The OCR recorded record level settlements that year. They believe it was in excess of $20 million, $23.5 million, as well as multiple multi-million-dollar settlements. But what's perhaps more interesting and illuminating for this presentation is the shifting and the OCR's focus, not so much as the size of the settlements or the amount of data that was breached, but more so focusing on and targeting underlying systematic compliance program failures. So things like lost or stolen laptops or devices, not having proper encryption in place, and then covered entities like under the High-Tech Act not properly overseeing and managing their business associates. So, so the message at that time for the industry was clear, where the OCR was shifting its focus, not so much from how big was the breach, but to whether or not there was a strong compliance program in place. And then finally, as Paul mentioned, under the TCPA, this was actually a very risky area and privacy because of the damages model of the TCPA. Mostly this litigation, and many companies across the industry found themselves in class action lawsuits, because of things like robocalls and robotext, things we're all very familiar with. And because of the damages model of $500 to $1,500 per call or per text, companies found themselves possibly incurring a significant exposure because of that damages model. So that's a high-level overview of a 2016 privacy enforcement landscape.
And all of those things continue today. So we're not seeing necessarily that these are going away, but now we've added a number of new areas of enforcement in 2026 that continue to challenge companies in terms of compliance. So I say know your data. So meaning more than ever, the government is interested and plaintiffs are interested in seeing companies that properly disclose or properly inform transparently about what their practices are with personal information. But additionally, how does that flow? Who accesses that information? Is it shared with third parties? And without knowing, directly what's occurring within your systems, within your data flows as a company, you're liable. You're likely to find yourself subject to liability or in violation of one of these many privacy laws. So you must know what you have, where it is, who has access to it in order to comply. And so that bleeds directly into some of the enforcement areas that we see. So business models that various companies use, whether that's so-called data brokers or this sort of more common sort of model of ad tech where Google or Meta or these other significant technology companies, they collect and use data in a variety of ways, but the main goal is to produce better marketing. And so there has been a focus in a lot of the current laws and enforcement activity on specific business models, not simply on the activity, but the model itself. And so we even see some enforcement and activity around the concept of a data broker. And so that's an organization that essentially sucks up a lot of data from individuals, but through kind of secondary sources. So they're not necessarily directly collecting it, but they have cookies or other trackers that they might use to collect data, or perhaps buy that data from other organizations. And so those models themselves can be suspect. And so it's important, if you're engaging with those organizations, to understand what kind of business model are you engaging in? What is the data flow? Again, know your data. We also see a lot more focus, and I'll mention a case later, where secondary use and sharing of data has become a significant enforcement emphasis. So rather than simply, we had a breach, an unauthorized hacker got into the system and is misusing our data, demanding ransoms, things like that. It's also, there's a focus on internal or even potentially company authorized use of data that runs afoul of perhaps the original intent of collection, the disclosures provided, the consent that should have perhaps been obtained. And so there's more of an emphasis on use of data within the company or through sharing. And then to cap all of this, a major point of emphasis is online tracking technology. So that's cookies, pixels, various other ways that data is collected through websites or apps, and then used in different ways. And a really key point is online tracking technology is a broad term. And I'll briefly show a slide, but I don't have time to go all the way through it. But that covers a number of different types of tools or code or scripts that can be on a website or in an app that significantly affect data flow and transfer and sharing. So I won't dig into all of these, but just understand that when I mention that, it's referring to a kind of collection of technologies. So we'll talk now briefly about some privacy claims, some enforcement activity that's taken place over the past few years. And we'll get into a couple of cases. Our focus will be mostly on health information and technology related to that, with the understanding that this audience will probably be more interested in that, though there is a lot more enforcement out there. And we'll mention a couple of cases that are maybe a little bit less health related, but have some key insights that we think are relevant to this group. So I'll pass it over to Josh to highlight one of the cases that was really a main kind of starting point for some of the enforcement we're seeing today.
Thanks, Paul. So GoodRx is a company founded in 2011. And for those of you who don't know, they offer prescription medications at a discount. And starting in about 2017, for about a 4-year period, GoodRx displayed on its website to users via different privacy notices and its privacy policy that their customers' personal information and personal health information would never be shared with third parties for advertising purposes. And they expressly said that it would never be shared with third parties for advertising purposes, and that to the extent it was shared with third parties, it would be for limited purposes otherwise. And the FTC alleged also in its complaint against GoodRx that GoodRx also displayed a HIPAA seal on its website, even though it's not a covered entity and not directly subject to HIPAA. So the reason why we're talking about this case is, of course, GoodRx did indeed share users' personal health information and with third parties such as Google and Facebook and Twilio and others for advertising purposes. And in the case of Facebook, actually shared users' personal information such as the health conditions they have, types of medications they were taking. So then a company like Facebook could generate targeted ads toward their types of medication they're on or health conditions they have. So using very sensitive information in a fairly egregious way. And so with the combination of the HIPAA seal, the FTC alleged this was further deceptive acts towards the consumers. And they also noted in their complaint and found it noteworthy that when GoodRx engaged these companies like Facebook and Twilio and Google, they accepted their standard terms of service, which meant that these companies like Google and Facebook were able to use these users' personal information for their own purposes. In other words, allowing these companies to profit from their customers' data. And so we just go on to the next slide and talk a little bit about the enforcement theories. So, like I mentioned earlier, the FTC's one of the main enforcement theories is unfair and deceptive trade practices. And there were multiple alleged violations of the FTC Act where GoodRx said they're going to do one thing in their privacy policy, and then in turn did another with persons' data. So, and then in addition to that, for the first time, the FTC used its authority under the health breach notification rule and found that GoodRx's acts of disclosing users' personal information to third parties without appropriate disclosure amounted to a breach of their health information. So what's the takeaway from all of this? So in addition to a $1.5 civil dollar, I think it was 1.5 civil monetary penalty and a lifetime or indefinite ban on GoodRx being able to share users' personal information to third parties for advertising purposes and loss of trust with the consumers, there are a few key takeaways for the healthcare and medtech industry. And the first would be that companies, of course, need to be truthful and accurate and with the information they put on their privacy policies. But even more important than that, and where the rubber really meets the road, I think, is ensuring that how data is actually used, shared, and so forth aligns with those privacy policies. Because going back to the late 1990s, early 2000s, the FTC and today has been using its enforcement authority against companies going back in the early 2000s against companies like Microsoft to today with companies like GoodRx and BetterHelp, finding that those privacy policies were inaccurate. But the last, I think, takeaway that we'd like to mention for this case is when Paul and I review our clients' contracts, when they are engaging with vendors or various partners or other companies, that we very often see that these other parties want to be able to use the data they're going to receive in performance of those services for their own purposes. We live in an age where data can be monetized, and especially with artificial intelligence, companies have an interest in being able to utilize the data that they might receive for their own purposes to perhaps, for example, train AI models. So, we would recommend that, companies pay close attention to those agreements when you're engaging with other companies to see what rights you might be affording those companies with respect to your data that you're sharing.
Yeah, thanks, Josh. And I would add to, some of the engagements we see are in these direct-to-consumer spaces where there's, an interest in who do we target these direct-to-consumer ads online to? Is it through ads, kind of stereotypically through, websites that people are visiting? Well, you need to engage an ad tech partner to do that. Maybe sometimes data brokers become involved, and those agreements are often very complicated, and they involve some potential sales of data or personal data or sharing of data in ways that might, raise the eyebrow of the FTC or other regulators. So we do see that pretty regularly. Just want to highlight a couple of other FTC cases. So this is not a standalone case, and there's many more like this, but there are a few others that involve health information specifically for companies that were not covered entities. So HIPAA did not apply to them, but they did have health information, through their website. And so BetterHelp and Monument are other examples where the FTC found that online activities were being recorded through cookies or other online tracking technologies, and then pieces of that information that revealed health data about individuals were then shared with ad tech or other third parties for advertising. Again, this is a really key point of emphasis for enforcement right now. So I'll just briefly mention this one because it's really the first major enforcement that we've seen under the CCPA, so the California Consumer Privacy Act. And so that was passed in 2018, and then soon after we started to see the California Attorney General pinpointing different areas of enforcement focus. So this very first one was about essentially that Sephora didn't do a good enough job of disclosing their sale of personal information and their sharing of that information for advertising purposes. And this also highlighted that in California, not only do consumers have the right to opt out of this kind of sale and sharing for advertising purposes, but they also need to be able to do so through what's called a global privacy control signal. So that would be a signal that their browser is configured to send, and then that is transmitted to the server that hosts the website, and they should then know from that signal to turn off tracking of this type. So that was part of the enforcement activity here. So we've known for a few years now that that kind of signal needs to be acknowledged and recognized by websites in order to avoid potential liability under this law. And one of the results here was that we saw that penalties would be in the same kind of vein that the FTC has been seeking in these same kind of actions. Another similar kind of case here, but involving health information. So healthline.com is a website that essentially provides information about various diagnoses or conditions. So if a consumer has, some sort of question about their health, they might go and find a website like this, search for articles about that condition, read them, and maybe read a few of them. Well, the thing that is happening in the background of a lot of these websites is that this information about consumers is monetized or used for advertising. And so it happened that Healthline primarily was using information like this as its main source of its income. And so the allegation here was that information that was being shared with third parties, monetized, and used for targeted advertising purposes was done so unlawfully. And so the problem was, even though Healthline had a banner that ostensibly opted out users from this kind of sharing, the banner was not functioning properly. At least that's the allegation. And so information, including things like article titles that users were reading or viewing, were shared with ad tech partners. And so, similar to the other cases we've talked about, this meant that third parties that had no connection to that individual were kind of indirectly receiving this information and could use it for various purposes. So you see here some of the same themes. Contracts with ad tech partners didn't have the mandatory terms that are required by the California Consumer Privacy Act for sale and sharing of personal information. They lacked controls around actual sharing, so consent banners weren't properly configured. And that ultimately resulted in a significant settlement and then some injunction of further sharing without user consent. And I'll pause here to give Josh the chance to talk about another very recent case that highlights another aspect of this law.
In February of 2026, Disney and the California Attorney General reached a settlement for Disney's alleged failures to honor consumers' opt-out requests using the Disney platform. So what that meant was the Attorney General office alleged that when users would opt out, for example, if you're on your laptop or you're on your iPad and you're watching Disney Plus and you opt out to the selling and sharing of your data, that opt-out was only working with respect to your iPad and on Disney Plus. So then if later you're watching ESPN Plus on your phone, or I'm sorry, on your phone, or yeah, could connect to TV, that opt-out would no longer apply. You'd have to re-opt out. So what they found was users might have to opt out up to 10 times in order to fully opt out from the Disney platform across all of their devices. So the Attorney General noted in a press release that customers or users shouldn't have to opt out to infinity and beyond, right? So that's like the key takeaway here is that for medical device companies where you might have a website for your company and then another website for your product and then an app that attaches to a device, to ensure that opt-out requests are functioning across the whole platform and not just one device or one website. So that's a key takeaway for compliance with the CCPA and many other comprehensive state privacy laws that have opt-out requirements. And the one more thing just to note about that really quick would be, Disney's defense in this was, that it would be really difficult to identify an individual across their various devices and platforms. But the Attorney General office did not find that very persuasive because they remarked that if you're able to identify a consumer for advertising across various devices and across different websites, then you're certainly able to identify them to honor their opt-out and data choices. So.
Yeah, thanks, Josh. And I'd add to that topic generally that opt-outs can be a tricky thing to administer. So there's upfront, on the website, you might have a cookie banner that says, reject all, so that they can opt out of kind of sale or sharing of their personal information at that point. But maybe down the road, they might opt out. You might have data that's already in your systems. There's other activities down the road that might apply to that same data set. So if they've opted out, that applies to the consumer data you've already collected that might sit in your customer record management system or other places in the business. And so that's critical to have some way, as Josh just noted, of applying those opt-outs across the board and not have it become sort of you have to opt out again and again for different segments of our record systems. And actually, before I dive into this next topic, I just want to briefly mention there was a case in the past week, so it's not in our slides, but General Motors had a recent $12.5 million, or I think about $12.75 million settlement for privacy violations with California Attorney General and other there are other parts of, I think, Los Angeles County, some other divisions involved as well, but the key point there was that they were selling information from allegedly from consumers who were using the OnStar system in their vehicles. And so their promise up front had been, we will only use this information to provide the services. You know, if you need our services through the OnStar system, we'll use that data. But it was found, or the Attorney General found that over time, they then kept that data for a very long period of time, for over 5 years after it was needed, and then began to sell that data to companies like LexisNexis and Verisk and these other sort of companies that could package that into a product to sell to car insurance providers. So there was a clear kind of challenge in terms of data limitations and use and minimum necessary use, which to date hasn't really been a primary focus of enforcement, but this concept of reuse of data later is a typical requirement in law. We just haven't seen enforcement like this until very recently. So we'll keep an eye on some of those developments, but that's a key case that we felt was important to mention. And then lastly, I'll just briefly mention this because it is a big topic right now. We have many clients who've talked about this with us, but California Invasion of Privacy Act claims and other kind of related claims are coming from plaintiffs, and the focus, similar to some other plaintiff litigation, is on the ability for the plaintiff to recover damages if these rights are violated. And so they're targeting, as Josh mentioned earlier, using this law from 1967 that used or targeted specifically phone calls and the wiretapping problems that they were trying to address in that law originally, but this general use of that law to apply to online tracking technologies that are common today. What's especially tricky about this is that if you comply with, say, the California Consumer Privacy Act or other state privacy laws, that does not necessarily mean that you've met the standards that plaintiffs are demanding under this statute. And you'll see the kind of the mitigation options below. A, you have to know your data, but B, the CIPA is being applied in a way that requires explicit consent before any tracking occurs, before any data collection occurs, which is a kind of higher standard than the implied consent with an opt-out right that the CCPA administers and most state privacy laws do. So that's a challenge. We're seeing courts divided on the applicability of this rule, and it continues to be a kind of a challenge. We will see where it goes over time. So what comes next? I just want to briefly mention, as we're running out of time here, we're seeing more and more regulation around artificial intelligence. We're seeing that in Colorado, although they just repealed and replaced the bill that had been kind of controversial on AI governance there in the past week. So we'll see kind of how that fleshes out and impacts other states who are thinking about the same kind of AI regulation. Many privacy laws include automated decision-making technology rules. California kind of leading the way again on that, but we're seeing that elsewhere. There's this concept of privacy risk assessment. And so many of you probably know what a quality system kind of risk assessment looks like. This is a little bit like that, but in a privacy directed way. So looking at what are the risks to consumers, what kind of mitigation controls are in place. That's becoming required by many state privacy laws, including California, which has finally released their rulemaking on that recently and finalized it. And then shifting cybersecurity requirements. So we are seeing states implement more strict cyber requirements for personal information. California has added some significant auditing requirements for cybersecurity that will kind of roll out in the next year in different kind of levels. And then we're also waiting to hear about HIPAA and how the security rule, notice of proposed rulemaking that we just saw not too long ago. It's been sort of silent, so we'll see if that comes out in part or in full as a final rule in the near future. So I think that wraps up our time, but happy to discuss later if anyone has any questions. Can you, for just a moment, Paul, also, you and I put an alert out, and just bringing this on a little bit.
There's a plaintiff's lawyer in California that's suing a lot of companies, especially in medtech. That's been kind of a popular target. I just thought it's not as leading as some of these cases, obviously, that you presented here, but maybe for the audience, just for a moment, because I know this is more of a nuisance type of plaintiff that will just cost you some money if you don't kind of yield to his demands. Or could you just talk for a moment about that? Because I know we've had several clients hit by it, so we actually put an alert out on this situation.
Yeah, and I think just to kind of go back briefly to this topic, we are seeing this happen to our clients. They're receiving demands based on the CIPA and other kind of related laws. This is real. It is happening. So if you have a website and there's any kind of marketing tools on there, you may be subject to this kind of, you could call it nuisance litigation, but it does have enough merit that courts are listening to it. So it's not just a summary judgment issue, but it's getting beyond that into discovery in many cases, depending on the facts. And each fact pattern is different. Each court views these fact patterns a little differently. And we don't currently have great kind of long-term ideas about what the courts will ultimately find. So we're still kind of seeing this play out. But again, this is a hot topic.
Just going to add that this individual has probably made enough money to buy a small island in the Caribbean with all of the settlements that he's garnered from the CIPA, right? So it's kind of, is that the law that it's the 1967? It's like some ancient law that he is citing, but then he's extracting settlements from companies. So it's kind of crazy.
And I'd add, it's not just one plaintiff. It's a number of plaintiffs that are bringing these actions. So someone mentioned kind of like copyright trolls a little bit, and I think it's challenging because the law just isn't that clear. And so although it feels really out there to us, as companies trying to do the right thing, it can be, I think from the plaintiff's perspective, they're saying, look, they're not doing it quite right. We're going to take advantage of that. So for now, I'd exercise caution and try to address this before you get a demand letter, in your mailbox.
Make sure you have a privacy policy on your website is the punchline. Like if you don't have one, you might get a demand letter. And, to present the plaintiff side of this, it's like people are collecting your data and who knows what they're doing with it, and they're making money off of it. So this individual is, helping police, if you will, the system. So that's kind of a part of our culture here in the US. You've got plaintiffs' lawyers doing lots of things. There are benefits from them, but it ultimately does drive up a lot of costs for industry, obviously.
Yeah, thanks, Mark. Thanks, everyone.
I hear you. Neil, right?
Yeah, you got it. Good.
Hi, Ann.
I hear you're a straight shooter.
Me? Yeah, I am. I'm a straight shooter. You guys can sit down anywhere you like. Yeah, you can just. I don't. Then we're getting one more. Anywhere you like.
Sure.
No back, have a chair. Okay. We are on the, Charlie, got to crank these up, Mike. We are on the final stride here. So I'd like to introduce my panelists. We're going to talk about a variety of questions that we covered today. And I know that our panel is in between us and the reception back here, so hopefully we'll keep this engaging. Okay, there we go. I'll just talk really loud. So I have Ann Miller on my left, and Scott Smith, Brian Phillips, and Neil Iodi from Nuwellis. AYOT, thank you. Nuwellis, Inspire Medical, Solventum, and Medtronic. So we have quite a panel here. And why don't you all introduce yourselves briefly and just say a few words.
So, hi, I'm Ann. I've been at Medtronic for 19 years. I'm in the legal regulatory group and kind of specialize in FDA and global equivalent issues. I started my career at the Chief Counsel's Office in FDA, and I'm a proud FDA alum. So.
Hi, I'm Scott Smith, and I'm actually no longer at Solventum. I quit a couple weeks ago, so I'm on a month off, which is awesome. I just would say that not working is better than working, in case you were wondering. But I'm headed back to law firm, but I'm an IP lawyer in general, and have mostly worked in either in-house or in law firms representing startups. So Solventum was my first big company experiment, which was fun for a little while.
I will say though, Scott, you've done it all. I mean, yeah, I know
Done a
you've
lot of
been
different things.
general counsel of medtech company, Aaron most recently. So yeah, depth of experience, and JD/MD. So watch out.
You got me sitting next to him, huh? Right? Brian Phillips. I am General Counsel, Chief Compliance Officer for Inspire Medical. Been there for about 5 years, a little bit over 5 years. Company has been growing rapidly over the first few years. The law of large numbers has caught up with us, and the rate of growth has slowed down a bit here recently. But still yet, we're presented with a lot of the challenges that I know you've been talking about here today. So looking forward to the conversation.
Hi, my name is Neil Ayat, like a big boat, a yacht.
I should have gotten that
it's good to
before.
meet
We've
you,
known
Mark.
each other for years, and I don't think I've ever had to publicly say your last name out loud. So,
Just
Ayat.
don't call me late for dinner. That's all good. I'm general counsel at a very small, publicly held medical device company called Nuwellis. Many of you might be familiar with its predecessor name, CHF Solutions. It was originally and primarily intended to treat congestive heart failure, CHF. But before that, I spent 16 years at Medtronic in a variety of roles. I am primarily an M&A lawyer, although I've been in-house for the last 20 some years. So as a consequence, I'm confident, and there's no false humility in acknowledging I'm the least qualified FDA commentator on the panel. But if anybody wants to talk about rep and warranty insurance or acquisitions, I'll be happy to weigh in.
That's what I love about this panel. We have all the disciplines covered because we have former FDA or OCC right here. So let's jump into it. We have a bunch of questions spread across various topics. I don't think we'll get to all of them. If you all have questions, feel free to wave your hand and we'll get to your question. I know online folks do the same, but I have plenty to entertain you here. So first off, Ann, I'm going to toss this one to you. FDA expectations continue to evolve. How should companies prepare for more complex interactions with the agency over the next years, the coming years?
Okay. So in the short term, as was discussed earlier, right, the changes that are happening at the FDA and that will likely continue to happen, I would say just be ready to pivot. Because you may go down a path and then the leadership change may come. The other thing I think in the short term, at least under the kind of the current leadership, there's a tendency to sort of regulate from the podium. So we're hearing about initiatives that maybe aren't rooted in guidance or regulation. So you'll need to pay attention, listen, read the trade press, call Mark. Kind of get a sense of what's going on.
Call us often.
Yeah. And then I think just generally, You know, FDA is, despite the attrition from last year, they're working toward, and their goal is to have increase the technical expertise in their centers and their investigators. And we've seen this, and I think we'll continue to see it. They are very, very, very well trained. They are technically astute. They are being, they will go, you know, toe to toe with industry more than they maybe have previously. So I think that we'll continue to see that. You know, I also think that because of that, you know, on the pre-market side, for example, you might see more questions on your 510K. You might see some deficiencies that you maybe didn't see in the past. So that sort of goes along with it. I'll stop. Maybe somebody
Thank
else
you.
has some
Excellent.
thoughts.
Other comments from the panel? How is, you know, what are you thinking about right now when you're guiding clients on the FDA going into the future and what's changing? You know, we just had a commissioner. Did he resign? I think so.
He did.
He resigned, but it was kind of telegraphed that he was being pushed out before that. So any other comments from the panel?
O'Neill was wrong. I'm the least capable in talking about the FDA, not him. So I'll
Race to the
pass.
bottom.
I'll pass.
Yeah, I think I'll add a few comments on my own. You know, what Ann said, there may be things that you were even working on as recently as last week or 2 weeks ago before we started to hear about the commissioner getting pushed out, that are his pet projects that are no longer perhaps going to be around. And so it is a time of great change. I know my friend Mac earlier said, hey, looks like your firm is growing. So the disruption and chaos in DC must be good for you. And there is something to be said for that. Plus we have, you know, things are kind of topsy-turvy. MAHA, we have, things are upside down that you know, you thought would be just tried and true have changed a lot. So I think it's going to continue for the next couple of years, be really interesting.
I will add, though, that one thing I have seen on the medtech or medical device side, which I think a lot of us in this room are in that space, has remained pretty stable through a lot of the changes. Dr. Tarver is still there, and a lot of the leadership is still in the center, so that's been good.
Thank goodness. Someone else commented that before when we were just out in the reception talking, is, you know, CDRH is kind of keeping their head down. Because we've got acting CBER, acting commissioner, et cetera. So it's a wild time. Yeah, and Michelle Tarver was just recently in Minneapolis. And so it's good to have someone steadfast at the wheel, and she's, yeah, as Ann's saying, really good, very well respected. But yeah, if you're in AI, software, digital health, QMSR, DTCA, if you're focusing on these things, if these are oriented to your job, they are changing really rapidly right now. So I'm going to toss the next question to Brian. Privacy, cybersecurity, and AI now touch almost every part of the business. I mean, you can't really get through a day without someone talking about AI anymore, right? How has that changed the role of the legal department? And I made a comment on my sheet here, like, you know, we have doctors complained for a while about Dr. Google, and now it's like AI Esquire. So I'd like to hear about just how privacy, cybersecurity, and AI, and how they're affecting the business.
Sure. I think the response to this question echoes a lot of the themes in Ann's response, just a different context, right? The pace of change technologically is just happening so fast. We just sat through a presentation discussion around data privacy and the rate at which that area of law in particular is evolving, the ways in which plaintiffs' lawyers are looking for theories and ways to pursue and go after companies to seek some type of monetary compensation. You know, all of those things are evolving. It's evolving quite quickly. I think along with that, most organizations, certainly my own, there is an insatiable appetite for doing more stuff and adopting more things as quick as possible, whether it's AI, use of AI in different parts of the business, or more and more data, right? We want more data about patients and our customers, and it's really difficult, candidly, for legal and compliance teams to stay in front of what is a growing tidal wave of the adoption and use of that type of technology and the collection of data. Really the best ways to manage are the tried and true, continue to deepen relationship, build relationship and partnership with different parts of the business, continue to elevate where and how these things can expose the organization to risk. And hopefully you will find someone in the organization that's willing to listen and understand that, while chasing growth and opportunity sounds wonderful, if it's done completely at the expense of managing and thinking about mitigating risk, then you're actually destroying value rather than creating value. Those are the conversations that I like to have, that I like to lean into. Again, it's difficult in this current environment where we look around and you think that your competitors are doing all of this stuff, and in order for you to compete, you've got to adopt it and do more of it. The last thing I would say is just important to be, maybe a couple more thoughts. It's important to be very intentional. For example, on the use of AI, I know we are behind. I assume most other organizations are behind as well, if we're honest. But I am advocating within my organization still yet that we be very thoughtful and have an overarching strategy for how organizationally we want to adopt AI and where and how we want to deploy it. Where do we want to prioritize those types of tools and for what benefit? And the final thing that I would say, and this is on the cybersecurity front, again, the pace of change, and I'm even hearing about how the bad actors are using AI to facilitate and get even better. I think the absolute best organizations are spending as much time on things like resilience as they are or had spent previously on threat prevention, right? This idea of we're gonna technology up and figure out how to keep the bad actors out. That sounds good in the presentation to the audit committee, but if you're not also talking with the audit committee about how you can quickly stand things back up after a breach has occurred, how quick you can detect it and how quick you can get those systems back up so the business can continue, then I think you're doing the business a disservice.
Some great points. Policy is it's behind, it's a laggard on the tech, right? And so we have a lot of people in this room that are responsible for keeping your clients safe, whether you're an attorney or a regulatory person, you're keeping patients safe. We are truly in a time where the tech is outpacing the law and the policies within the companies. So it's just a matter of what breaks, right? We'll see. But there's obviously great fruit to be yielded from AI as well. Any other comments, Scott, Neil, want to add?
Yeah, no, I thought that was what everything Brian said. But yeah, it's almost like it's the AI push is, at least from my perspective, is at the level of being kind of annoying. It's like just adopt it, use it more, even if it means that 20% of you will be laid off because your jobs will be gone or whatever. But there's very little thoughtfulness, I think, from the push to just adopt everything super quickly. And it's just like, okay, this assumption that technology is good, and so just take more of it. So I like if you're able to actually from the legal department, push a slowdown and a more thoughtfulness. That's amazing. I haven't seen that done yet.
I actually received a HR complaint regarding the use of AI by a very senior member of management. And she said, she's a medical professional. She's like, I had a conversation with this guy, and within minutes, he wrote me an email capturing everything I said, and I know he doesn't understand it as well as he put in his email, and I think I'm being recorded. I'm like, well, I've never had that one before.
Yeah.
And the same individual was capturing minutes from a national sales meeting and publishing them, all the issues we talked about a short while ago around privilege or transcription, automatic transcription. And it's a little tough to coach them out of it, because it's a strong tool, used properly. But I think we're going to see more and more use cases where it's not being used properly.
Yeah, no, it's ubiquitous now. I mean, I wouldn't be surprised if one of you is recording this whole day, right? Like, I taught a class in Shanghai last summer, and one of the students, I kind of looked down and everything that I was saying was being recorded, and I was like, I don't care, you're paying for the class. But, it's just a different era. And so, yeah, I could see where people are not wanting to be recorded, and they are all the time.
Well, this same exchange between these two individuals, there was a market assessment of a new area for product development, and the more senior person presented the market opportunity, and the more junior person, who's the medical professional, said, "You didn't use this database. This is the medical society database that quantifies the actual number of procedures." And the implication was, you just put it into GPT.
Yeah. So it is interesting. I know we'll move on to the next question here, but Jake is somewhere in the audience. But we were kind of like, no one knows who this client is anyway, so I can tease him a little bit. But they're sending us all these documents, and Jake's like, well, I don't really feel like I should be billing for all this because it's kind of garbage. I can tell this robot created all of this, and I'm like, oh, let's tell them that we need. Send us what we need, right? Ultimately, don't send us what your robot thinks we need.
I was just going to add one thing, though, in addition to the internal management of AI in your companies, there's also the external, people who are being encouraged to use AI. Never, ever, ever, ever use AI to generate a quality system record without reading it. I know it sounds obvious, but that's basically what happened. There was a pharmaceutical warning letter a couple of weeks ago. So it seems kind of like a no-brainer to me, but you can see maybe how it happens because people have this false sense that somehow AI is more qualified than, an external consultant. But
Totally. They scan it and go, that looks good, hit send. And then, I mean, there's been plenty of lawyers disbarred and disciplined and things like this that we've read about where they're citing cases in briefs that don't exist. The court system's really struggling with this right now.
I have a suggestion in regard to that. I just recommend sprinkling a few typographical errors throughout your brief.
Okay, yeah. Put some typos in intentionally. I'm sure the college kids have figured that already. Okay, next question here. We're only on to the third question. So my little timer isn't on. How are we doing on time? 15 minutes, great. We'll just keep going until about 8 o'clock. Does that work for everyone? When government, and this is for Neil, when the government scrutiny arises, what are the first mistakes companies should try to avoid?
Well, to share some inside secrets, as we prepared for this panel, Mark acknowledged that he used ChatGPT to generate the questions. So I used ChatGPT to answer.
Perfect. So we'll just get like Claude and Gemini up here talking.
So I will distribute my handout with all the responses. It was helpful. It was useful. My first thought is document hold notices, kind of preserving the evidence, preserving the record, identifying the appropriate witnesses. And, I work in such a small organization. Most people haven't been involved in the types of matters that we've likely been involved in, certainly Ann and me at Medtronic, and they haven't been involved or advised by Ropes and Gray or Hogan Lovells or King and Spalding. And I was told very young, as a very young lawyer, there's nothing wrong with being ignorant. You just don't know. You haven't had any exposure. But a reminder about attorney-client privilege and work product and, as I said, kind of preserving the record would be some of the first things that I would try to think about.
Anyone else? Call your lawyer.
Yes.
Maybe, Amanda talked earlier about the good documentation practices. This is a little bit off base there, but, not sending an email probably to everybody in the company. Maybe call your lawyer or call the lawyer within your company and have a meeting with them in person before turning into Chicken Little.
And the right lawyer, someone who has familiarity with internal investigations or regulatory enforcement actions.
We love giving those trainings because we have a couple little bits with them, like the James Bond rule. Don't write, destroy this email after writing it or burn it for your eyes only. Let's take this offline. Vivian could probably tell us about this. There's been complaints where people are in a meeting and they're saying, take it offline, and they have that recorded. And it's kind of like, what are you doing offline? What are you talking about? So there's I mentioned the Chicken Little. There's also just not calling for action that's never taken, not providing legal advice if you're not a lawyer, but
don't reach a premature conclusion either.
Yes.
Let the facts develop, unfold, and take your time to reach the right conclusion.
Yes. All right, toss over to Scott here. In areas like HCP interactions, reimbursement support, pricing, discounts, what makes the risk analysis harder today than it was 10 years ago?
I did not use ChatGPT for my response, but I was super excited that Amanda and Lisa and Jake already covered this really well. So I refer you to their slides for the answer to this question. But no, I would say that I haven't been a general lawyer for my whole career, but I guess maybe the last 10 years. And I would say for all those things, it's just all of those items are bigger issues now. And my theory is that it's all because, when I first started, and again, working for startups primarily, there were a whole bunch of different risks in a company. I mean, there was, technical R&D risk, FDA risk, IP risk, reimbursement risk. And I feel like now it's almost 99% reimbursement risk. And almost all of those things like pricing strategy, obviously reimbursement consulting, it all comes back to the fact that we can't get paid for anything anymore, especially new devices. And I mean, even compliance, it's the salespeople are going out and they're just doing something that that they feel like they have to do to sell these devices. So, I mean, if you're looking for advice from this panel, my advice is don't ever go to or work for or start a medical device company where you don't have a really clear reimbursement strategy from the beginning. Don't do the thing where, like Amanda was saying, where you think, I'll figure out this awesome new device and I'll figure out how to get paid for it later. Don't even go to a place, because you've heard of these where they have kind of a half-baked reimbursement strategy, like, I think we'll fit within this code maybe, and then we'll do, we'll get our CPT code later and blah. I mean, reimbursement it's a horrible, horrible thing, and it dominates everything. And I think that has changed a lot in the last 10 or 20 years.
It has. Quantitatively, you can see how the appeals have gone up, the rejection and denials have gone up, so it's an environment that's gotten so much more difficult. And then, the last thing you want to do is sell your customer a product and then say, good luck getting paid for it. So companies have to provide reimbursement support to stay alive. And it's a dicey road. You got to do it right.
Well, our customers are more sophisticated than that, right? They're not going to buy.
They will not. The VAC won't buy it.
Yeah, and we're going through that right now. So I don't know if you intended to rip the Band-Aid off and make this highly uncomfortable for me, Scott. But
no, I was at Aaron's. My last company was ENT, so we're closely related, even though we just met. But it's a rough area.
It is. I'll just comment a little bit on things that beyond the reimbursement topic, but on some of the other reimbursement support and fair market value analysis and how how we are supporting the business and some of my lessons that I've learned, I am increasingly shifting my advice and counsel to be more downstream focused, right? I can answer your question today. I can set you on your way today, but I am going to also contemplate how you might use this advice 6 months from now without coming back to talk to me about how you're going to tweak it, right? Yeah. And so I will make conscious choices, perhaps depending upon who it is that's involved, which team it is, about how conservative my advice might be up front, and or intentionally build in checkpoints so that, requiring 6 months from now or 12 months from now, or, whatever the product development, or not a product development milestone, but whatever the necessary gate might be, let's just build in and let's check again. Like we might launch a pilot, and I might render advice based on the limited use application of the pilot. But before we shift to full commercial, let's have another conversation, right? And build that into the overall process.
It's a great point, and this is often overlooked. If you do have that luxury, I mean, things are at breakneck speed, right? Constantly. The reality is, investors have a lot of options right now with what's going on with AI and everything around it. So the dollars can be invested in a lot of places, and medtech is one of them. So the speeds are breakneck. But if you do have that ability to get ahead of your model, you might be able to go, like Amanda and I have several times, to the OIG for an advisory opinion. The problem is that takes, what's the fastest we've gotten one, Amanda? Like 8 months? We had one that was, they can be 2 years sometimes. I do think they've gotten faster, but if you can get your business model reviewed before you launch, whatever it may be, whatever inventive thing that your sales and marketing people come up with, you can get some comfort there, and that's great for investors too. But the reimbursement environment, it is a can of worms. It's a tough one, and I agree with Scott completely. Any inventor should be thinking about reimbursement right away. Obviously you got to get the product locked in, its design, and perfect it, but you should be thinking about how it's going to be paid for. Reality is, in our system, if it won't be paid for, it will never make it. It will not.
Mark, I'd like to go back to a point that Scott was
Please.
making earlier. Amanda did a great job, great slides. I loved those FCA recovery statistics. And I thought, a little constructive feedback, the one statistic that I thought you were going to share, and I think is very informative, is DOJ frequently, I don't know if they do it annually, will indicate their ROI on investigation dollars. And I want to say it's 1 to 6.
It's massive.
1 to 8. And I think that really informs the enforcement environment, and everybody's fighting for their budgets. And if they can recover, they're better. And if it's 1 to 8, it's incredible. And a quick plug, I know you know Howard Root, the local former CEO, who was criminally indicted for, I think, off-label promotion. He wrote a book called Cardiac Arrest, and it's great. It is, I mean, if you're a compliance nerd like many of us are, it is well worth the read. And it has the added virtue of being set in Minneapolis, and you'll recognize many of the names and the participants and the lawyers involved.
I would also plug that book. It's a fast read. I teach at U of M Law School and also Mitchell Hamlin, and it's required reading for the course. But I also make them watch the Bleeding Edge, which is a expose, if you will. I mean, it's a hit piece. Let's call it for what it is. It's a total hit piece on the medtech industry. We're all evil. And so my point is, I'm trying to show them both perspectives, because Howard's fantastic. I mean, I've known Howard for a long time. He is definitely on one end of the spectrum, and the Bleeding Edge documentary is on the other end of the spectrum. And I'm trying to get the lawyers to appreciate that the truth is always somewhere in the middle. But yeah, it's a tough world out there. I'm going to hand this over to Ann. What role should legal play in FDA inspection readiness, quality system issues, or other significant regulatory correspondences? And I kind of added a note here, like, do you horn in and be pushy and try and keep tabs on everybody, or how do you kind of, or do you react? Are you proactive? I kind of would just love to hear about that.
Well, because I've been there 19 years, I don't have to anymore. But there was a time when you kind of had to, get a seat at the table and then, provide input and value. So, I mean, started in the 43 inspection warning letter area response. And, I think if you can demonstrate that even though you're the lawyer, you're not afraid to ask the dumb question. I mean, there have been times when you just ask the dumb question and it's kind of identified an engineering gap. I mean, I don't know how that happens, but you just read it and something doesn't add up, something doesn't sound right. So you bring your critical thinking skills. For writing, you bring your writing skills. You just want to make sure that whatever you're communicating to the FDA or whatever regulator globally, you're answering the question, you're transparent, you're answering it, fully enough so that it doesn't invite 5 more questions. And I think that if you have, regulatory experience like people in your firm, you can really add a lot of value, especially if you're at the communication standpoint. But I think that if you can, try to get involved in the issue early on, ask questions, learn, understand, and then, as you're moving through whatever matter you're working on, if you get to the end, just be able to, over time, learn how to, I guess, add value, but you will, because it's not being afraid to ask the dumb question is really what I have told people over the years.
Absolutely. Yeah.
Yeah.
Any other comments?
Well, I really benefited, particularly at Medtronic, from being around professional project managers and trying to adopt their skills and practices. They're great at project management, but they don't have the analytical framework or the legal acumen to let them run a process like that, because you have a unique point of view. And to the extent you can take the ball and quarterback and use some of those good skills and practices, I think the output would be much more effective.
Yeah. And also don't slow things down. I mean, that's I think a misnomer, sort of speaking to how I try to work. I never want to be the reason that something is delayed. So you have to be able to turn things quickly.
Yeah.
I find I just met in when we were getting prepared for this. I'm not sure that we really are asking dumb questions. I think a lot of times you label something as a dumb question. It's sort of the back of your mind, the common sense kicking in, and you're not seeing all the dots connected, but asking that question and approaching it from the perspective of someone who isn't an expert actually injects a lot of value in those discussions, because it allows you to frame the issues more simply and figure out how you might go about solving the problem. Again, without years of experience and levels of expertise that a lot of other folks around the table might have.
No, I think that's a fair point. And I would say it this way too, is not being intimidated by the fact that you're having a conversation about, some battery functionality with a PhD, an engineer, just that you bring a different lens. You're not there to talk about the engineering. You're there to talk about how you're explaining your point.
Right.
So, yeah.
Those are some great points. I would also just add, I know we're all on the same page on this, but work with FDA. They have a busy job. They have 1 million files on their desk. I remember working on many enforcement cases saying, how can I help you get this file off your desk? Like, what do you need? Like, let's get this 43 address. Let's get the warning letter closed out. And they love that, right? Like, there are times where you have to push back. I could get into war stories on that, but working with them, collaborating with them, they're trying to protect the American public. Work with them to satisfy them, but hold hold your stance if you need to. I know we have 26 seconds left. I know we have a lot more questions here, but I think rather than keeping you all, I'll just end it. I really appreciate the panel. We can tape these to the bar, and then anyone can go up and ask any one of us if you like. Is anyone? Yeah, we should do. I think we got time for maybe a question. Oh, okay.
I didn't hear a ton of talk this afternoon about the cybersecurity aspect of it, the St. Jude Muddy Waters debacle, the SBOM, the vulnerability management program, cybersecurity management plan that you're supposed to submit, threat modeling, all these new requirements that have come in. So I'm interested to understand how the lawyers in the room who probably aren't well versed in those issues are bridging the gap with the cybersecurity team with medical device companies.
Yeah, anybody can take that. I will just say that this is clearly a very hot topic in industry. There's people ransoming all the time. It's a hot, and I don't think that our country really has it totally locked in yet. My 2 cents. Please go ahead.
I think D&O insurers or liability insurers generally have great resources and great tools, and they would love to come in and do tabletop exercises, training, and to bring that to an IT function and get the benefit of their best practices and response. And it's free. I mean, they want to do that.
Anyone else want to jump on that one?
I'm not sure I understood the question. Just kidding. Just from a technology standpoint, right? But no, I completely agree with that. What Neil's comment. Partnering with the IT team. You're right. The lawyers are not the experts on the technology side, but we do help with the IT organization as they are implementing processes that allow for us to achieve, a different certification that speaks to the ability of the organization to withstand cybersecurity attacks. I get involved as well on the review and presentation of materials, as I alluded to earlier, to our board of directors. They ask a lot of top-line questions. Again, it doesn't speak to a lot of the detailed back office reporting requirements and meeting whatever the current standard might be. But as I said earlier, I am a huge fan, and I've come to simply accept and have a high degree of skepticism to any IT professional that spends more time talking about how they're not going to get in rather than convincing and sharing what we're going to do once they do get in. Right? Just from a credibility standpoint, I think we all have accepted it's no longer if, it's just a matter of time. And the organizations, the best ones are prepared when and once it does happen.
All right, let's call it. Thank you very much to the panelists. Awesome job. And we will be around. Tracy has a comment. Please go eat the food behind that wall. And here's the bar. Sam is happy and ready to go for you. So soft drinks, beers, whatever you want. Thank you, everyone. Thanks for coming.
Yeah, I started patent attorney at Townsend & Townsend in Palo Alto. And then went in-house at the Company Line.